Okay. Okay, pardon, one compromise matter, my lord. Offense under 498, 13B has already been allowed by the law and court below, my lord. Yes.
Sorry?
Compromise matter, my lord.
Admission of Belgium matter.
My lord, item 59 of the list.
Yes.
Item 59 of the list.
Yes.
My lord, the matter was amicably settled between the party. Your lordship may keep it to next week so that I will file the affidavit, my lord, of the both the parties.
Next week. Yes.
Your lordship, can I
Good
mention a
date
matter?
to call him dock 7 तारीख तो okay. Okay. Interim order to
Yes,
continue.
Now,
My lord.
Rat.
My lord, interim
TRLNC 3510 of 2023 on 2nd January, Lordship has pleased to allow me to surrender before the 14th session. But unfortunately, as my father-in-law was expired and the ritual was going on, 12, 13, 14 was holiday. And on 15th when I appeared, that was the last date. So I couldn't, so I need the extension. I have filed an IA 147 of 2024.
This is
3510 of 23.
3510.
Lord, 59 interim order to continue.
Yes,
Lordship,
Mr.
will it be
Mahapatra. Okay, we'll reach. Yes.
Your lordship, item 14 in today's list, it was specifically adjourned for today at 2 p.m. I request your lordship, my senior is not available today. He's on accommodation. So can it be taken up
Then
next?
let it come. I will note it down and let it come. We'll see. Huh? We'll adjourn it. No problem.
Okay.
Yes. Yes. And anybody online mentioning?
Yes, my lord.
Yes.
In TRLMC 5218 of 2023, my lord. Initially, I was granted bail due to non-filing of chemical examination report. That was interim bail. And I have came before this court for regular bail, my lord. Passing of the interim and made it to regular bail, my lord. In the meantime, my lord, the interim bail, after completion of the time, I have prayed for regular bail. As the chemical examination has been submitted, his bail was rejected, my lord. So in CRLMC, my lord, 5218, 2023, maybe mentioning that.
You are challenging the non-granting of bail order in 482?
No. Initially, I was granted interim bail, but I have filed.
Whatever the bail, see, 482s are not meant for bail disposal.
No, my lord, I have prayed, I have came.
Okay, you give the memo, we'll see. We'll list it and when the matter will be heard, then we'll see.
Yes,
Yes.
I beg pardon. Make mention, my lord. Lord, two matters. Earlier also I had mentioned, but it has not come yet, my lord. One criminal miscase number 5505 of
If it
2023.
is very extremely urgent, we will immediately list.
Lord, because
Otherwise,
the trial
it will come
court is-
under a, we
Trial
already-
court is now proceeding to frame charge, my lord. I have challenged the
Cognizance
order.
to argue everything on charge instead of wasting energy here. You will be discharged.
Compromise.
Settle.
Compromise.
They will file a joint affidavit. What is the offense?
No, they have filed the affidavits in the court below, my lord.
Ajay, what is the offense?
Offense is 420.
Take it up.
And another matter.
Settle, na?
Again,
Settlement has already taken.
the affidavits are filed. I have enclosed everything in my
Then we
application.
list it. We list it.
And one more criminal miscase, my lord, where the complaint case has been dismissed for default, my lord. I filed an application for restoration. That has been rejected by the court below. That is against that I have come up.
Take it.
I beg pardon, my lord. My lord, earlier I have already mentioned in this matter, my lord. My urgency is, my lord, this is the passport matter. Due to pendency of the criminal proceeding, my lord, the Honorable Court below I have made the application as per section 6 of the Passport Act.
Passport is seized or is the condition of
No, my lord, it is a renewal of passport, my lord. And during pendency of my renewal application, the Honorable Passport Authority directed that unless until you will give that document, then I will reject your application. So I will prejudice, my lord. So this is the urgency, this is the only urgency, my lord. Because the Honorable Court below,
take it, find out space and
my lord, I have already mentioned earlier.
find out space. Yes.
This matter was specifically adjourned to 25th. As the Honorable Court has not functioned on the railway.
Take it up. Take it up. Space will be there.
Fresh CRLMC praying for quashing of FIR.
What is the urgency?
The urgency is that
Investigation
First.
is on.
investigation is over. Charge sheet has been filed. Only difficulty is that summons are being issued by the
Bail is
court.
rejected.
205.
Therefore, 482. Give the memo.
Oh, please.
Item 59, there was an interim order. That may be.
Yes. Yes.
Against the interim order in the DB proceedings, stay has been obtained.
Item 1.
No.
Mention.
Mentioned in the interim order against DB proceedings, stay has been obtained by husband. He is not paying any interim entrance till for last 2 years. I pray vacation stay may be taken up. The wife and children is facing some
What,
difficulty.
was there any settlement?
No. In the DB proceeding, interim order was passed by the land court below, challenged by the husband and stay has been obtained.
Take it up. Maintain it.
Obligement.
Yes. Item 1.
Item 1, my lord, here the matter has been subsided between the parties and they have ready to file the affidavit. May I plead to be taken up day after tomorrow?
Now, what happened?
The matter has been settled between the parties.
They have settled. What is the offense?
307, around 50 persons are the accused persons.
50%.
50%.
Injury?
Usually kitchen, I guess.
Where is injury report?
The report, well, I will file it. So,
There
here I have
are,
not filed, I'll file it before.
if there are 57 people, 9 people have come here. 9 of them have come.
Again,
So all of them might have attacked.
it's in June. The murder. If 50% will assault with an intention to murder, my lord, know what will be the consequence.
File the report also. Okay.
And maybe
They have settled, no?
I can
Settlement. Bring them, file joint affidavit.
Yes, madam. The injured will come. Madam, because of the fact that 9 persons are there.
Injured and informant also.
Yes, yes.
Both of them, but
Yes. And what is the stage of the
Investigation
not completed.
Investigation on.
this village fight, na? We'll see who
Madam,
get the
madam,
injury
injury report along with the informant and injured, they will appear in
Yes,
process.
yes.
Madam.
Okay.
Day after tomorrow, madam.
Day after tomorrow is huh? Day after tomorrow would be first.
Third. Sorry, second, madam. I'm sorry, second.
Second lady.
Okay. Okay.
Item 2.
May I bless you? Offense under section 363 and 66 of the Indian Penal Code. The meantime compromise has already made between the parties, my lord.
The learned counsel for the petitioner submits that the petitioner number 1 has now merits with the opposite party number 2 and they have set.
No. Opposition to the mother of the victim, my lord.
Okay. Informant.
Informant.
Where is the victim?
Victim is with me.
But you are not impleaded. Impleaded come.
Yes, ma'am.
Okay. Impleaded come. Okay. Let him
Item 3.
May I please, your lordship?
Yes.
In this case, last occasion, your lordship has directed to me to file the affidavit along with the judgment of the learned trial court where the acquittal has been given to the some of the accused. Offense under section 20B2C and section 29, your lordship, read out section 29. I am the owner of the vehicle. My name is solely implicated as the owner of the vehicle. I have my name has been
You are not
in position of the conscious position, nor the vehicle is with me. Vehicle they have taken in on rent. On that day, on the eventful day, the vehicle has been caught hold by
you are not neither in the spot, not
Not-
apprehended.
not
Subsequently, you were
yes, so charge sheeted in the subsequent, and
you absconded.
yes, absconded due to that later on my name come into in picture in the charge sheet. That reason I have remained.
What you filed? Yes.
I have filed, your lordship. Kindly have a glance.
Yes. Annexure. Copy of the
Copy of the judgment of the learned trial court, your lordship.
Yes, Mr. Ragada, just check it up.
Madam. No, that was given, madam, but in the page 44, madam, is specifically, madam, while taking cognizance, madam, in another court below, since the investigation kept open, madam, under section 370, subclause 8, madam, arrested to these 3 persons, madam, they have absconded. Hence, the investigating officer is directed to explain as to whether the accused persons, namely Devraj Pradhan, Saroj Kumar Sahu, and Rakesh Petitioner, Chandra Sahu,
are where available in their respective address and are willing to the investigation officer not to arrest them or investigation officer not arrested them on their arrest was not required under the provision section of one of section 1
Yes.
of section 41 CRPC.
Hmm.
That aspect I will take instruction.
Lordship, I may submit, your Lordship. I have filed an IA before your Lordship. That is there, your Lordship. Can I have a glance to that IA?
70.
Yes, your Lordship.
Hmm.
That IA, the judgment of the learned trial court, I have annexed, your Lordship,
Hmm.
where the acquittal has been made to that Devraj Pradhan, Rajesh Chandra Sahu and Arjun Behra is acquitted by the learned trial court, holding that the offences has not, the prosecution has failed to brought the offences against the present, the accused persons.
Right.
Kindly have a glance that judgments.
Which page?
Page, your Lordship, that is page 19, your Lordship.
19 of the
19 of the IA, your Lordship.
19 of the IA. Judgment, which paragraph you tell me?
Paragraph 13, your Lordship.
13.
Yes, your Lordship.
Okay.
May I place from paragraph 12, your Lordship?
Hmm.
From the analysis, evidence adduced by the prosecution in its entirety does not inspire confidence about the allegation of search and seizure of ganja by the police, especially when the independent witnesses have completely denied the factum of seizure. The brass seal has never been produced before the court. The chemical examination report has not been brought to the record, and that there are serious.
What is this? Chemical analysis report is not there. Oh, independent have not supported.
Yes. And your Lordship, this honorable court judgment.
Which paragraph you read from the judgment?
Paragraph 12, your Lordship. 12 and 13.
12 and 13. Who all are these people?
Only one petitioner.
Where is the allegation against you?
Again, your Lordship, kindly have a glance that FR, that charge sheet, your Lordship.
Yes, which that's it. Yes.
Charge sheet page 26, your Lordship.
Yes, 26.
20B2C, 25 and 29.
Yes, yes.
And charge friend under section 20B2C and 29.
20
B2C
20B2C
and read with section 29.
20. Lego. The petitioner has filed the present petition under 482 CRPC seeking quashing of the entire criminal prosecution against him. Oh, no. Quash of the order. What is this order? 2612.
That is cognizance order, your Lordship.
Challenging the quashing of the entire proceeding initiated against him, and the cognizance order dated 26/12/2022 passed by the special judge Fulwani in CT case number 38 of 2022 on the ground that the other co-accused persons, namely, who all are the co-accused persons?
Your Lordship, Rajesh Chandra Sahu, Arjun Behra and Devraj Pradhan.
Rajesh Chandra Sahu, so and so have been acquitted by the learned trial court after the full phase trial by its judgment dated 14/8/2023. The gravamen of allegation against the petitioner is that he is the owner of the offending vehicle. However, there is no material placed on record or any allegation made against him regarding his presence in the spot where the contraband was apprehended from the other accused persons. Okay. So, the petitioner has brought to the notice of this court the judgment of the learned which court here learned
Assistant system.
learned special court Fulwani in dated 14/8/2023 in city case number क्या है
38A of 2022.
38 city case number 38 of 2022 and 38 bracket capital A of 2022. The paragraph 12 and 13 the said judgment is relevant for the purpose of disposal of this petition, which are reproduced as under 30. The perusal of the judgment indicates that the prosecution have not even filed the chemical analysis report in the present case, and none of the witnesses, independent witnesses, have supported the prosecution. Therefore, the trial court recorded an acquittal order in favor of the co-accused persons, those who were apprehended from the spot. The next slide. The petitioner is the allegation against the petitioner is he is the owner of the offending vehicle. Full stop. Taking into consideration the aforementioned facts and circumstances of the case, I am of the opinion that putting the petitioner to trial on the strength of the evidence available on record would be a futile exercise. Therefore, to meet the ends of justice, it would be appropriate that the entire prosecution against the petitioner needs to be quashed. Accordingly, the petition is allowed, and the cognizance order dated 26/12/2022, passed by the London Special Judge Pulwani so is quashed, and the entire prosecution launched against the petitioner is dropped. Yes.
Leave urgent copy.
You write that the Mr. Ragada appearing from the state has opposed the prayer made by the petitioner. However, he could not controvert the fact that no chemical analysis report is placed on record, and none of the witnesses, independent witnesses, have supported the prosecution, while the other main co-accused persons were subjected to trial.
Only one prayer, your lordship. My name may be reflected to the order sheet.
Write down the name, and Mr. So argued for. Take a. Yes.
Item 4.
Yes.
My lord, here, my lord, the Nagaland SDGM has taken cognizance under section 92
Yes.
for violation of the Factories Act, my lord. Here, the present petitioner has retired long back, my lord.
That is the time of offense he must be working.
No, my lord, at the time of offense, he was not even at 18 also, my lord, he was not the occupier, my lord. He was, my lord, he was in the higher ups of the management, my lord. He was not the occupier. That is the whole submission, my lord. Secondly, my lord, if it will, my lord will see the nature of allegation.
Let us see the complaint. You
Yes,
are
ma'am.
Mr. What is your name is Mr. Jami Devraj.
Is
Devarji.
Kurewala.
Kurewala.
Devrajji Kurewala.
Acha, Kurewala. Okay. Let us see what is you are the owner.
My lord, no, my lord. It's a Powermax company. It's a subsidiary of that graphite company, my lord. So what has happened, my lord? One of the employees' palm got severed while he was doing the machinery work, my lord. It hand got stacked up, and it palm got severed, my lord. Before, my lord, they went for the compensation. They have to claim compensation under the Employees
Factories Act. Yes.
Without doing that, my lord, straight away the director of Factories Act, assistant director of Factories and Boilers has filed a complaint against us, my lord. First, my lord, that has.
Who are you?
My lord, I'm one of the directors of the company, my lord. Now I am no more the director. Also, I have retired, my lord. Meantime, so now the present another petitioner who is over here, he is the manager, my lord.
What is occupier means? What is occupier?
Occupier means, my lord, the person. It has been defined over here.
Give me Factory Act section 90.
Occupier of a company, factory means a person who has ultimate control over the affairs of the factory. That is, my lord.
You are the owner that way. That means you are the owner of the company.
Yes, my lord. That has to be the owner of the, has the complete control, my lord.
Do you have a vicarious liability for criminal?
Vicarious liability, my lord, that only can be assessed after the assessment under the compensation case has been finalized.
Section 90, prosecution is section 90.
Section 92, my.
92, let us see.
Yes.
What does it say?
In other two cases, my lord.
On facts, you can't make out a case. You show me if you law, if you
Yes,
supports then.
yes.
Fact don't.
Facts, because facts are there, my lord.
Whatever may be the facts in 482 code will not go into the
Yes,
fact.
my lord.
If
Yes.
you have a case on law, you tell me.
Yes. On law,
Yes.
my lord, what I am to submit is this, that I am not at all liable.
Show me the offense.
Offense, my lord, is
92.
72C. First, 92 is the
Penalty provision. What
penalty.
then?
My lord, the long list of offenses, my lord, they say that it is very 72C, my lord, 7A to C.
And 22.
Yes, my lord, then 22. First, my lord, let me read out 7A to C. The provisions of such information, instruction, training, and supervision are all necessary to ensure the health and safety of all workers at work.
Provisions of such information, instruction, training, and supervision. Yes. 22.
22, my lord.
Hmm.
I quoted in my.
Let us read the 22. Work on or near the machinery in motion. Whenever in the factory.
It's a general, my lord, all are general. Where in any factory it becomes necessary to examine any part of machinery referred to in subsection while the machinery is in motion as a result of such examination to carry out in case referred to in clause 1 of provision to subsection 1, section 21, lubrication and other adjusting operation in case referred to in subclause italic 2 of the provision aforesaid, any mounting or shipping of the belts or lubricant or other adjusting operation while the.
Yes, Mr. Ragada, you tell me one thing. This gentleman who is the petitioner here is not in this spot. He is a resident of Mumbai. Okay, he is the owner. Under the aid of 7 and 22, how will you bring the vicarious liability against him to prosecute for this offenses?
That respect, I'll instruction, my lord. But the lordship can issue notice to the open party 2, my lord. They made the party.
Mr. Issue notice to opposite party number 2. Mr. Ragada, accept note, appears for the state and waives notice. Copies you got it. Copies you got it. Notice. Okay. Returnable within 2 weeks. And then a notice on the interim application as
My
well.
lord, similar case, my lord, proceeding has been stayed, my lord. We have brought those orders, my lord. Similar same Factories Act, section 92, my lord. Same persons, my lord.
Same person.
Yes, my
Then you enjoy that.
lord.
Why should you another order?
No, another, because another proceeding. This is another proceeding.
In how many cases you are involved?
My lord, only 2 cases, my lord. 2 cases, 2 persons, my lord.
Two persons received injury.
Yeah, no, 2 persons received injury, my lord.
And there are 2 prosecutions.
Yes, 2 prosecutions.
In the other prosecution, you got the stay.
Stay, my
Let
lord.
us see. If he is other prosecution, then the stay you have to give. And thereafter, you will not come. That's the problem.
No,
They'll
no,
seek
no.
adjournment. That's the problem.
No. Never.
Once the stay is granted, then
No,
you
my
start
lord.
avoiding
No,
this.
that is not the case. Because
But
they are
that-
genuine cases, my lord. These are people, they are not in direct supervision of the.
Mr. Stay. Yeah, you are showing two orders.
Yes.
There are 2 cases.
Yes,
This is
ma'am.
third case then.
Here 2 cases, my lord.
There are two persons, my lord, 2
No,
persons.
you are showing me 2 cases now.
My lord, these are because the factory manager is also involved. There is another case here, my lord.
Here 2 cases.
Here there are 2 cases, another 2 cases where stay was granted.
Here also there are 2 cases.
Yes, ma'am. 2 cases.
Also now
Here
today,
1 case 2 persons. my lord.
One case, 2 persons, my lord.
persons.
Cognizance has been taken against 2 persons.
who
In
was
another
the victim in this case?
a victim in this
Victim
case.
in this case is
My lord.
victim you have not implemented also. Victim is important.
Yes, ma'am. I will.
In this case also you have not implemented victim.
I will do both.
How you have you got the stay without implementing the victim?
That is, my lord, in that Deuterary Nag, my lord, because here, my lord, the because we have not implemented him because here the director of factory, assistant
But he is the
director.
complainant, but the victim in a factories act, who is the beneficiary?
But
You
my lord, the
implement it come
but-
tomorrow.
My lord, my lord.
And this stay also you, the honorable judge escaped notice.
I don't know, because my lord,
Because you have not implemented.
my lord, here,
I've
my
seen
lord.
both the.
Yes, my lord, I got it, my lord. I'll implement them, my lord. What has happened, because we have not implemented because of the assistant director of factories.
He
has
is
lost
the
that job.
informant, sir. He is the informant.
He is the
And
informant.
in a factory's case, the
My
person who has received injury
My
is the
lord will
beneficiary.
My lord.
Like in 307,
I'll
if
do
there
that.
is an informant and there is a
Definitely,
victim.
I'll implement.
If there is crossing, then
Right.
both the informant as well
Yes,
as the
ma'am.
victim have
I'll
to be
implement. I'll implement.
we implement, put it tomorrow.
Yes, sir.
Both the case.
Item 5.
Yes.
May I please, Lord Swan? In this, that's a settlement between the parties, my lord, where the offense under section 341.
Settle.
Yes, my lord.
Who are they?
I am for appeal number 2.
Oh, where are the parties?
Parties
What is the
are-
offense?
But affidavit is clear. Offense under 341, 294, 323, and 307 is there.
Three injury reports from.
Injury report is annexed of 3, my lord.
Yes. What is the
There
injury?
is no injury, my lord, at all.
Simple or what?
ସିମ୍ପଲ ବି ନୁହେଁ, ସେ ପଛରେ ଗାଧଉଥିଲେ, ଗାଁରେ ପଛରେ ଗାଧେଇଲା ବେଳେ ପାଣିରେ ପଚେଇ ଦେଇଛନ୍ତି, that is the ମିଛରେ ପଲିଟିକାଲି ମୋଟିଭରେ ଗୋଟେ କେସ୍ କରିଦେଇଛନ୍ତି. And present petition is a police honest matter. Facing harassment.
Mr. Rogada, just check it up.
Madam.
What is this?
Another
Internal injury found.
another thing, my lord, let me adjourn, my lord, and the both parties will appear before this court, my lord. So they have filed the joint affidavit, my lord, they have their person
You bring them at 2 o'clock.
Yes, my lord.
today.
Today, ତାଙ୍କ ଘର ଫେରିଙ୍ଗିଆ କନ୍ଧମାଳ. Kondho, that is belongs to Kondhamal.
Second February.
Yes, ma'am.
Bring them.
Yes,
2nd
ma'am.
February.
Yes, ma'am.
Okay. Next.
Criminal proceedings is under police petition is a police honest.
Second, I am keeping it that is the reason. Don't ask for stay. I am very reluctant in giving stay because once stay is granted, then you keep on adjourning matter.
Yes.
So it is better that finish it up.
Yes, ma'am.
That's the best way of doing it. Yes.
Item 6.
Yes. 6.
Under the vehicle seized and the bowler 22/9/2019.
What do you want?
The matter is pending before STM due to release of a vehicle.
Yes. 457 application.
That was rejected.
Huh?
That has been rejected, my lord. Thereafter,
Revision is also rejected.
Rejected on the ground that a confiscation proceeding already started.
Then what can you do? There is a confiscation proceeding, then you have to face that. If there is a proceeding, separate proceeding is initiated,
For that,
then
yes.
you have to face that.
My lord.
Yes, basically confiscation.
Was this an application under 457?
My lord. Court will file before the court below, thereafter revision of court. And revision of discussion on the ground that confiscation.
Where is the operating part of this or 21? Because the petitioner had moved an application under section 457 CRPC seeking release of the vehicle. Which vehicle is that?
Bowler.
Vehicle bearing number so and so. Bolero vehicle bearing number
OR 014 M 8538. Page 21.
OR dash 14 dash M dash 8538. 38. 38. Being the owner, you are the owner.
My lord.
Being the owner of the said vehicle. The learned SDGM court rejected his application. By order dated 29/8/2022. The petitioner brought up the matter to the revisional court by filing revision petition 3 of 2022. The revision court, namely the Learned Sessions Judge Devgad, while its order dated 19/12/2022, rejected the revision petition. Inter alia, stating that, inter alia stating that since a confiscation proceeding has already been initiated, the application under 457 is liable, is not maintainable, not maintainable. Maintainable. Next paragraph. The said fact is not controverted at the bar. Hence, I find no reason to interfere in this matter, and accordingly, the petition is dismissed. Next.
Item 7.
Yes.
Passing of the entire criminal proceeding, my lord. Arising out of matrimonial dispute on the ground that the mutual divorce has been, which has been filed before the learned family judge Cuttack, my lord, that has been allowed. This is the copy of the mutual divorce, my lord. Also, the opposite party to
Status report also called for, my lord. That is a
status report
Flag
regarding,
C.
my lord, what the
you'll also
present.
call for the status report, my lord.
Hmm.
That is flag C. And
What is the status report? I have passed. Have I passed the order?
earlier, my lord,
Only because, my lord, whether the, what is the stage of the case, my lord.
What
And
is
the learning court below has answered, given report there, the appearance, the issue, notice has been issued for appearance. All they are on bail. After bail, my lord, the charge sheet has been filed. And
in the the mutual divorce petition, have the lady said that I will not
yes, my lord, that copy I have saw.
show me.
Mutual divorce.
Which part?
Your lordship. Page 3, your lordship, kindly have glance, my lord.
Yes.
Paragraph 4, clause IV, my lord.
Mutually agreed to dissolve their marriage. The court, among the other factors, has exclude the possibility of consent of party. Where is that? And mutually agreed to dissolve their marriage before and after the petition was presented. Where is the recitation that she will not continue with the criminal case?
Also, affidavit also before this honorable court, my lord. That
Where is that?
affidavit has
Yes, ma'am.
at flag, my lord.
And for the opposite party too, my lord. I'll the
The
affidavit.
opposite party too has appeared and also filed an affidavit before this honorable court.
Appeared?
Yes, my lord.
Yes.
When? Where is the affidavit?
At flag C, perhaps.
Flag C or flag B?
Flag B, please.
Jyotirmay Samak.
Yes, my lord.
नहीं
नहीं सो मत appear कर दिया affidavit.
नहीं नहीं
अच्छी अच्छी flag भी अच्छी बात.
कोर्ट को ऐसे नहीं.
Which paragraph of this affidavit says that filed in this criminal? I have gone through your case. And
Paragraph 3 and 4.
And connection with ठीक है. Has she appeared?
She has appeared through his counsel.
I am appearing for the opposite party.
Why she is not appearing?
DB case to
DB case and 498 case. 498 and DB
Two
case.
cases, my lord.
Both the cases are. What about DB case? What happened?
DB case is also pending
Also pending before the learning court below, my lord.
What are you doing there?
for appearance, my lord.
What are you doing there? Will you withdraw that?
Yes, my lord.
No, no,
He has to say.
If
He has to say.
it is quashed, my lord, then why they will proceed?
Huh?
If it is quashed, my
No,
lord,
this
then
is only there are two matters here.
two matter and we have filed the two
Second one,
separate.
second one is, my lord, 3740, my lord. Second one is 3740, my lord.
No, where is this lady? Tomorrow there may be some problem.
No, now, my lord, mutual divorce has been allowed.
That's right, but in the mutual divorce, nothing is there. Can she appear 2 o'clock today?
2 o'clock.
Virtually, I am not interested that she should come. Phone କରିଦିଅନ୍ତୁ ଦୁଇଟା ବେଳକୁ virtual ଟିକେ ଦେଖିଦେବେ and you will be safe.
Your lordship, keep it,
Another date, my
2 minutes, my lord. I will make a call to him so that.
I am keeping it 2 o'clock. Pass over it. Take it on record and tell her to appear. Because it is
Only informant, my lord. But that lady, my lord.
lady.
My lord.
Because see, I'll tell you, this is safer for you.
My lord.
It is always safer for you.
My lord.
Tomorrow he is appearing, some complaint will come.
Oath commissioner, my lord.
affidavit before the outcome.
You never know of this matrimonial.
Yes, ma'am.
This is very
3,50,000 permanent alimony she has received.
You will do it in good faith, some complaint will come tomorrow. Why unnecessary? Call her. I'll record as present and finish.
My lord, my lord.
Item 8.
On which she should come.
Pardon, my lord.
On virtual mode she should come
Oh, bless
for
me.
2 minutes. Okay.
8 same matter. 7, 8.
7, 8, na?
7, 8 both, my lord.
Both.
9.
Infructuous, my lord, compared to withdraw.
Infructuous.
Thanks, my lord.
Very good. Infructuous.
They have been arrested, my lord.
Yes. And your petition is also very nice. Only one FIR and 482.
Yes, sir.
Yes.
10. Passing of proceeding on the ground matter. Matter has been compromised between the parties. To put up.
Compromise. What is the offense?
Offense 354, 506.
Okay.
there.
Where is the girl?
Your lordship, next week, I produce me.
When?
Next week, any date, your lordship.
Next week. Settle.
No, 13, my lord.
Oh, 30? No problem.
13, 8.
13.
Oblige.
Okay. Yes.
Item 11.
Oh, sorry. I am sorry, my lord. Item 10, I party करनी. Complete करनी, sorry.
It's a kamal yaar.
They are my mistake.
Then what will you do? She is not a party, then
Yes, I
also
file a mistake.
Mr. Patel submits that the parties have settled in the dispute. However, he has not made the informant as party to this proceeding. Therefore, he seeks liberty to implead informant as opposite party number 2. Liberty opposite party number 2. Let the amended memo of party be filed during the course of the day. Issue notice to the opposite party, newly added opposite party number 2, or returnable within 1 week. 1 week. During the course, you give.
Just now.
Okay.
Item 11 and 12, man. Next week. Charge sheet copy. 11 and 12.
11 and 12, you have not filed charge sheet. Copy of charge sheet.
Yes, ma'am.
11 and 12 adjourned. Yes.
Next
13.
week.
Item 13.
Pass over.
Item 15. Item 14.
2 p.m.
2 p.m.
2 p.m. Pass over. 15.
15.
That's the item praying for an adjournment.
Adjourned. 16.
16.
Pass over.
17.
Pass over.
18.
Pass over.
19.
19.
May I please, your lordship?
Yes.
This application was preferred before this honorable court solely challenging that the order of cognizance on section 307 of the Indian Penal Code against the petitioner is not tenable in the eye of law. That is the whole grievance. So far the other offences are concerned. I am not saying that this is a case where entire criminal proceeding is required. Before going to the merit of the case, I would like to draw my lordship's kind attention. There is a proverb in Oriya. Pandita puo mankad marle dosho nahi. Exactly, since the police personnel are the informant and witnesses in the case, 307 has been added.
What is the injury?
Injury is on the finger.
26 and 20.
Your lordship may turn to page
26
annex.
to 29.
At page 26, first injured, small scratch in the left forearm.
Cut mark on the right side of eyebrow. The identification mark. That identification. Where is the injury?
2 persons sustained injuries and those
Scratch.
injuries are scratches.
Left forearm. Cut. Okay.
Scratch on the left forearm.
No external injury. No external injury. Cut mark and left forearm.
My lord, may I submit? My lord. But
I know what you submit.
but the question is,
cognizance stays.
yes, sir. I mean, the question is not the the person concerned was sustained injury or not sustained injury doesn't mean anything, Milord. Because it is to be considered whether the intention of the person who is going to cause the injuries, whether it amounts to 307 or not. The spur of the moment it will be considered. What he did. Your Lordship, I am reading the sentence. The situation in which the informant, the police persons, no doubt about that, they are the police persons. Where they are. But in deliberately attempting to cross the police person who were on duty with an intention to kill them. The vehicle was driving by the petitioner and he was in drunk and he was obstructed by the police, did not stop, tried to cross the police person.
Ran over.
Yes. That is why some police persons have sustained minor injuries. That does not mean that 307 will not attract. The intention of that situation will be considered. Because मारी देते 307 ହେଇଥାନ୍ତା କି attempt ଗୋଡ଼ ଫୋଡ଼ ଭାଙ୍ଗି ଯାଇଥିଲେ then 307 ହେଇଥାନ୍ତା. ଗୋଟେ ଗାଡ଼ି ନେଇକି ଜଣେ ଯାଉଛି, he was obstructed.
In the cognizant
It's a case of 307.
The statement you argue on discharge, you will be discharged on that section.
Hello?
Cognizant stage, why should the 482 code interfere? I record your statement.
Yes, your Lordship is right on that point. May I say one thing?
Yes.
Suppose I will file a petition for discharging under section 307 after commitment. Then the process will continue. It will consume the time of the court. Again, the case will
Right,
come.
you are absolutely right. But see, in the cognizant stage, if I'll start analyzing the medical report, all this is
No, I am not saying the
crossing the limit of 480.
Yes, exactly. The court, while taking cognizance, should apply the judicial mind to the fact it is not a mechanical process. Whatever the offence has been quoted by the police, the court will take cognizance. The court is to peruse the record and satisfied that the ingredients of the offence is fulfilled.
Completely satisfied because there is whether there is an intention or there is no intention. In
Yes,
cognizant
yes.
stage, how do you elucidate?
On that point, my friend has read out on the charge sheet itself. Your Lordship have a glance to the affair itself.
I read the.
Yeah, informant, who is the informant? Informant is a police havildar.
I know.
Where is the allegation of that he intended to cross them by way of driving in a rash and negligent manner over them? They said that what happened, they gave signal that was not obeyed and the vehicle was dashed in the PCR van and the accused tried to pray away from the spot. And by that process, they sustained injury. That is the allegation. So where is the question of inception of 307 of the Indian Penal Code? As because they are the
Will
police.
you move application or argue on charge?
Ma'am?
Will you move separate application or argue on charge?
As your Lordship, I placed
Record your statement. You have a good case maybe, but not in cognizant stage.
Your Lordship may observe that the petitioner moved the application at the appropriate stage.
The petitioner has invoked the inherent jurisdiction of this court under 482 CRPC, seeking quashing of the order dated 8/7/2022, whereby the learned trial court has taken cognizance under section so and so, including under 307 IPC. 307 IPC. Mr. Mahapatra, the senior counsel, contended that insofar as the offence under 307 is made out, is concerned, the same is not made out on the basis of the allegation and the injury report placed on record. I have perused the contents of the FIR and the injury report. I'm afraid at the stage of cognizance, whether this court should analyze the nature of allegation and the injury sustained by the victim. Therefore, this court is not inclined to entertain the present petition at this stage. However, liberty is granted to the petitioner to raise all these points at the appropriate day and in the appropriate proceeding before the court below.
And the
With
Learned
this-
Court
with
will
this-
consider
with
it
this-
on its own merit because
Obviously, at this with this liberty, the petition is disposed of.
Hon'Ble.
Item 20.
I have not used the word dismiss. I have not used the word dismiss. I have said disposed.
No, why I said so?
You have a
Sometimes-
case. I'm sure that you have a case, but
No, why I said so, sometimes the subordinate court, they thought that since High Court did not interfere in the matter, why you will, that is the,
No,
that's
you
why I
have to
said
see
that
the
he
stage
will
of-
apply his own mind.
you have to see the stage also. Yes. Next.
My lord, the learned trial court took cognizance under section 376, 511 IPC, C8 POCSO Act and 32B SC
What
ST
is
Act.
what was the age of the girl?
Madam,
What was the age of the girl?
13 years. Actually, what happened, your lordship kindly have a glance on the FIR. FIR, she narrated that she used to work for 2 years in the house of the accused person. And within 2 years, accused never misbehaved her, nothing else. On that, your lordship kindly.
Sir, how will I analyze this 161 statement and everything at the cognizance stage?
My lord, cognizance is illegal because of
Cognizance is
two
also
points.
not maintainable because this application is also not maintainable.
No,
Charge has already been framed. If the cognizance will go, then how the charge will?
You have
it would have
I have
challenged the
also
charge.
filed
you have
for
a
questioning
you
of the
have a
charge
remedy
sheet.
under the revision. Challenge that.
Charge
Withdraw it
already
and
framed
challenge
on
Charge already
24/5
framed.
2023.
But
I think trial
for questioning of the charge sheet as well as cognizance.
No.
Your lordship
Charge
kindly.
has been framed, file a revision, you may have a good case.
Your
charge
lordship
I'm not sure.
kindly have a glance on the FIR. FIR see again kichi कहली खाली कहिची just undressed her and attempted to rape.
সেটা ঠিক যে কিন্তু কথা আছে আপনার চার্জটা আসবে না
Maybe 13-year-old girl, the statute is so draconian, what to do?
So, nothing else, man. This is a cognizance.
Better you file revision. Because charge has already been framed, you have a remedy there. Unnecessary, why are you exhausting the remedy and invite something? I see in cognizance order, I can't quash. I can't go into, I'll write something, then your revision is also unnecessary get affected.
Regarding questioning of the charge sheet, my lord.
Charge sheet will not be quashed.
চার্জটা ফেমিলিতে চার্জশিটে কেমনে করে ইন্টারভিউ হবে
Charge is, withdraw and try your luck there. The present by way of the present petition, petitioner is challenging the seeking quashing of the charge sheet, quashing of the charge sheet, and also challenges the order dated 25/3/2023 passed by the learned sessions judge come special judge under POCSO Act, taking cognizance of the offence, cognizance of the. Mr. Maharaj, next one. Mr. Maharaj, appearing for the state, informs the court that meanwhile charges have already been framed
on 24/5/2020
on 24/5/2023. At this stage, the learned counsel for the petitioner submits that he would prosecute the other remedy available under the Criminal Procedure Code insofar as the order of charge is concerned. Therefore, seeks to withdraw this petition. The petition is dismissed as withdrawn with the liberty to the petitioner to avail the remedy, under law.
21.
Making a short prayer, the 138 NI Act, I am the complainant. So he is now suffering from cancer, but defense is accused is not cooperating. So I pray the time stipulation be given to the presiding officer, JMFC, for expert disposal within the time frame. Complaint,
Your client is suffering from cancer.
my lord.
What is the check amount?
Check amount 7 lakh, it has 7 lakhs, 22 has 8 lakhs.
He is appearing in the trial court.
Appearing, accused has already appeared, but not cooperating in the trial.
He is the accused in both the cases.
Both the cases.
Then total check amount is?
No, my lord, husband, wife.
Total check amount is?
Pratham check amount, my lord, 7 lakhs.
The second?
8 lakhs something.
Will he pay?
My lord, no, I'm who to complain.
I know, I understand. Will he pay? Has he offered you?
No, he has not offered any.
What is your age?
My lord,
What is your age?
my lord, age is 65.
I'll issue notice. Let us call them and persuade them to give the check amount. And
Yes, sir, Lordship.
Unnecessary, why?
Obliged, my lord, obliged. Cancer patient.
I'll put it next week.
Yes,
Issue notice to the opposite party in both the cases. We will persuade him.
Yes, my lord,
Both
obliged.
wife and husband to
Obliged.
pay you, and
Okay.
since you are suffering. And
Sir.
issue notice returnable next week or call them.
Sir.
Serve them and bring them.
22 also same.
22, 21, both.
23.
You also open a dialogue, since you are suffering, even if I'll target it, you get a conviction. He will go in appeal, and
yes.
20% only you will get it.
Yes, my lord. Statutory deposit, he'll also be right.
Better sacrifice something, get something,
Yes,
at least
my
in your lifetime you'll get. Otherwise, he'll, prolong by paying 20%.
My lord, he'll also has the deep insight.
Therefore, that's better. Yes.
23.
May I please, your lordship?
Yes.
Entire proceeding is under challenge. That is, your lordship accuses the trust. The present petitioner is the chairman of the trust.
You are the accused.
My lord, I am
Yes.
the accused. And principal accused the trust. Trust has not been added as the party. Your lordship, that is in a series of cases, your lordship will see. Supreme Court has decided this point. That principal accused is the state. So state.
You are the managing trustee.
No, I am the chairperson of that trustee, my lord. And on the basis
For
of this,
company, there are judgment. What about trust?
my lord, trust, that is educational trust. Gonasika Education Trust. And
Now, what about this judgment? This is
that is,
trust.
your lordship, in that case also, London High Court, your lordship.
No,
High Court
here it is a trust or
this is a company, your lordship. Here is a
company,
trust.
though I know company that.
Here is a trust, your lordship. Very decent.
Give me trust.
That is a trust, exactly the same. Vicarious liability, your lordship, office of the
It's a
trust.
Vijay Lakshmi trust.
My lord,
They have quashed it.
they have got it.
Right. You are challenging which entire proceeding?
Entire proceeding, your lordship.
The petitioner
My lord,
is the chairman
my lord.
of which trust is that?
That is, your lordship, chairman of Gonasika Educational Trust. Gonasika Education Trust.
Gonasika
Education Trust.
It is alleged that on behalf of the trust, a check of rupees, how much?
1 crore. 7 lakh.
1 crore.
1 crore. Some
Where is the complaint?
nine
Where is the complaint? Yes.
My lord.
1 crore.
9 lakhs.
So was issued in favor of opposite party number 2.
My lord.
Full stop. The said check was dishonored. Therefore, the petitioner is now prosecuted by the opposite party under section 138 NI. Full stop. The petitioner submits that in the absence of the trust, the petitioner being the chairman of the trust cannot be prosecuted. Therefore, the complaint itself is incompetent. He relies upon the judgment of this court in Bijay Manjari Satpathy versus State of Orissa, passed in criminal so and so. Wherein the coordinate bench of this court in that said case quashed the complaint petition under 138 NI since the trust was not arrayed as a accused. Arrayed as an accused. Arrayed as an accused. Issue notice to the opposite party number 2, returnable within 2 weeks. In the meantime, the proceeding in the proceeding, where is the application? Proceeding in 1 CC bracket N LACT number. This you take in the, from the application phase 2. So and so is stay till further proceeding. Yes. Next.
24.
Here.
Item 24, I've got a limited grievance, my lord. It only comes to that page NX1, page 8. The matter listed 130th proceeding. It is pending for JMC Kantamanji. I am the complainant. You
Yes.
also see at page 9, that in 18 February 2022, that 130th and proceeding is filed along with the application under section.
You call the earlier
One four.
earlier council just please. Earlier council. Call. Earlier council. Yes.
Yes, you also see at page 9.
Hmm.
It was filed way back in 18 February 2022. The other side is appeared. But the Relevant trial court session over the matter, neither disposing the 138th proceeding nor the petition under section page 11 at 148 of the NA.
You by sorry, 1 minute. By next date of hearing, you also file the 138 statutory notice
My lord.
and the reply which you have given.
My lord.
You also fly. Whether in the reply have you taken this point? Otherwise, 139 presumption will operate against you. You may not get the benefit. Under that presumption, you have to face the complaint. So you file it. Okay. Yes. Sorry.
Yes, sir. I have got limited grievance. I am a complainant before the court below. The matter is session over by the JMC Kantamanji, proceeding under the 13010 Act.
Yes.
And also page 10, it was filed since 18 February 2022. The other side has appeared. And learned court in session was lingering. The still till late, nothing has no trial,
What
nothing
is
has come.
the check amount?
That you'll also see at page 8, 5 lakhs.
5 lakhs.
Yes.
This amended 148A application. What happened?
That is also pending, not taken over. The other side is already appeared, but some plea or the other is taking time. Learned court in session was met also granting
Let us
adjournment.
see, issue notice to opposite party number 2, returnable within 2 weeks. Opposite party only. Opposite party. Returnable within 2 weeks. Give a date. Let us see.
My limited grievance was let the.
We will see that.
As well also.
Because 148A application is also there.
Yes.
If he will pay. Okay.
25.
Yes.
May I please? My lord, I have a very small prayer, my lord. For completion of the trial, for early completion of the trial. My lord, my annexure 1, page 8. Since 10.
What are you challenging here?
My lord, I have not challenged. I have prayed for early completion of the trial. This is a case of 2015. Trial commenced on.
What is the offense?
Offense 302, my lord. Trial commenced on
19. The FIR is. When was the FIR?
My lord, FIR on.
You have not filed anything. What to? How?
No, I have filed
what is the FIR? What is the allegation? What is the stage of trial? Nothing is there. Only you file. It is like a school student moving an application for leave.
My lord, I have the entire order sheet, my lord, I have filed by the learned court below, my lord.
Where is the FIR? What is the allegation? How many witnesses are there? How will I know? How many witnesses are there?
My lord, 19 witnesses.
Why? Where from you got it? I will expedite. Then I'll then we'll see 50, 60 witnesses are there. How will you?
My lord, there is 26. I have taken abandonment, my lord.
Where from you got from the entire record that there are 16 or 17 witnesses?
My lord, it is mentioned in page 8, my lord. Itself, it is mentioned that the issue summons fresh to PW7. 17, sorry, my lord, 17.
So therefore, only 17.
No, my lord. My grievance is that since 9 to 2016 up to 10/1/19, the PWs have examined. Since 10/1/19, not a single witness has been examined.
See the 6/9/2019, the accused Hajra, no PW present, issue summons to witnesses 18, 10, 19, so and so. How many witnesses are there?
26 as per charge sheet, 26 witnesses. And when on every date, no PWs are present. No PWs are present. Since 19.
Yes, Mr. Maharaj, just see what is happening, because see the proceeding indicates that the
Yes.
PWs are not present. You are in custody.
No,
You
madam.
in
No, no,
custody?
he is not cost,
No cost.
not cost.
No,
He-
4 years.
Yes.
4 years, since 4 years, not a single witness, my lord. 19, 20, 21, 22, 23, my lord.
Yes,
Just see the order dated 26/3/20, 27/3/20,
yes.
14/7/20, and 15/7/20, and in
Up to
18,
17.
19/8/20, and 20th August 20, and 25 September 20. Where were you? Accused absent, accused absent, accused absent.
But on that, there's
You
also,
just see the
my
proceeding.
lord, I have seen.
Yeah, how many days you are absent? Why are you complaining prosecution? You are on bail, you don't go to the court, and you expect that the trial should be expedited.
That is, my
How
lord,
much cost, you tell me, to dismiss it?
my lord, that is,
What is this? You are filing 482 petition. You were, just see from page,
so that, my lord, it a corona,
just see from page 13 onwards,
my lord.
proceeding you see.
But should have,
Just see the proceeding.
my lord, 13, 14,
How many days? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17,
during corona.
18. I'll keep on counting.
17,
In all these days you are absent. Today you want that it should be expedited.
my lord, 3, page 17, 3, 11, 21.
You can't read the proceeding isolatedly. It is not, rather she is trying to help you to explain.
My lord, that is,
Sometime it may be Corona 21, 21, 21, maybe Corona time, but thereafter also you 22 you are not present. Again 22,
my lord,
you are not present.
my lord, 22.
Even then you are not present.
No, my lord, in 22, I am present, my lord.
No, no, I will not. Okay. Simply you just try to do it yourself. I will not, because this petition, these very casual petitions are, you will not file a list of witnesses, you not make any.
I mean, I have taken aberments, my lord.
Don't reduce the High Court level of practice to so low. You are such a senior counsel.
My lord,
What see, all the juniors are looking at you.
my lord, I may be permitted to file the charge sheet and the.
Withdraw it and file. Some, or otherwise I'll dismiss it with some cost, pay to the bar council. It will be helpful to the junior counsels. And then you file a fresh one. Because you are senior, therefore I'm saying. Raise the standard of the bar to little more, you know. This petition, withdraw it, huh?
And I, with the liberty to file and one.
Liberty is always there.
My lord, one thing I.
Then Mr. Parijal and counsel for the petitioner seeks to withdraw this petition with the liberty to file a better one.
Better.
My lord, one prayer, my lord. The certified copy I have already filed.
Exemption. File exemption from not worried. Exemption from filing advertisement and file and take it. File a better petition. Take every day. And something you are accused.
The check number in the statutory notice, the check number in the statutory notice and check number in the complaint varies.
Then in the statutory notice, why have you not replied?
I have not replied, my lord.
Then?
And on the face of the complaint, we'll have a glance to page 50 in the complaint. Let's have a glance to page 50,
Yes,
my complaint.
Hmm.
Page 4, it said that accordingly the complainant deposited the said check in ICICI Bank branch at Khordha on 10/11/2020 for withdrawal of the check amount, but to the author by the complainant said
Now, what is your case? The check numbers are different.
check number different, even the dates are taken to consideration.
Have you signed in the check? Your signature is there in the check.
My lord, here Lordship will
Check
appreciate.
its signature is there.
I am coming. I am a signatory, but it is a case I have taken loan. And post-dated
All
checks,
these things are different.
security.
See, if you have signed a check and statutory notice is given to you, you have not replied, then the presumption operates against you, you have to face the trial. Simple.
While the statutory notice, even taken to consideration the averment, it is beyond the statutory period. Let's have a glance.
You have to raise there, sir. I
Let's have a
can't.
On the face of record, it cannot be because after 30 days, no statutory notice can be issued.
Then you raise those things there in the court below.
That will be.
How can I quash the proceeding you have taken? You have signed the check and that you are admitting.
On
that the
10,
check
on
is there.
10/11, the insufficient intimation was received. Then he is supposed to make a.
How much you owe to the accused?
That is not 6 lakh. They are saying that 6 lakh something. 6 lakh 50.
Check is 10 lakhs.
Check of 6 lakh 58,000.
You owe that much. Admitted.
That is the check amount.
No, what you owe? What is your liability?
I had,
Legally
tek- I, had
recoverable
tek- I,
liability
had
according
tek-
to you.
I had taken loan of 10 lakhs.
Hmm.
And now they said they foreclosed the account and my security check was used. And I
You have paid the entire.
no, I have not paid the entire
How
amount.
much you have paid out of 10?
About 3 lakh something I had.
Then legally recoverable is there.
But when there is
Will you deposit that? I'll finish up the matter entirely.
this amount, I am not at this stage of.
You have taken loan, you 10 lakhs, you have paid
But
3,
when
not paid the rest
when the
amount.
proceeding, when
under
the
the shadow of some
proceeding requires a
technicality, you want-
statutory complaint, let's see, appreciate, kindly appreciate. When the proceeding requires,
I am not on technicality. You will show 2 technicality, I'll find out 5 technicality against you. That's not the issue. Issue is 10 lakh rupees you have taken as a loan, 3 lakhs or 4 lakhs you have paid. The remaining amount in any case you have to pay. For that you have paid the check, you have signed the check and the check is reasoned. Now you tell me, will you pay some installment or some?
on the date of issuance check, there is no debt as such. Because it was a security PTC at the time of before granting me a loan. That is the fact.
Whatever, but you owed man, legally recovered due is there.
But that is the recourse lies also elsewhere, not 138 proceeding. And with face of record, a notice was issued.
You don't want to pay.
But I don't want to
That's the
face,
underlying thing.
no, I don't want to face the proceeding. This is malicious
Order
proceeding.
37 you will face, but not here.
Hello?
Order 37 fruit you will face.
That's it. There, I have a right to prove my liability over there. In 138, my scope
Will you give the amount on installment basis? Then I will issue notice.
that I have to
Pay
take.
it back. At least all the legal proceedings will be.
I have to take instruction. But my client is.
Come on, see. See, the 138 matter is over. No suit is filed against.
Malicious proceeding will be given a green signal to green signal to go ahead because here
I will record everything. No further proceeding. You pay and finish up.
I will take
Why should you suffer 2 proceeding for longer time? Try to appreciate that.
अगर मुझे trial का test कर भी there is chance of acute.
I will pass, sir.
And even if I go to the merit, my lord, my debt is by limitation.
I know.
In the civil proceedings, they cannot
That's what you are
succeed.
insisting on that, so that once you get out of it, then you need not pay.
Because they did not proceed against me within the limit,
They are hampering up in this proceeding.
my lord, and they wrong proceeding. After the statutory period, how can they issue a demand notice under 138 Act, my lord? And how can on the face of record?
If you instruction, let us see. If you
My lord.
try to be fair also, that technically you may have a case or you may not have a case, but the fact that you owe the money, you have to pay it. We will fix the installment. They also know the problem. We will fix the installment, it pay.
May I suggest, my lord, in that case, let me take notice to the other side. Also, in the meantime, I will take instruction from
Give the notice to the opponent party.
May Lordship please the.
I'll not stay.
My
Only for the purpose of exploring the possibility of settlement, I am doing it. And
requisite
doing
within,
it after 2 weeks, we'll see.
requisite within 2 days.
Ah. Ready?
Next one for, that's.
I'll just write.
Page 20, my lord. Para 5, my lord. That all the cases pending in between or either be withdrawn or compounded in lieu of aforesaid mutual compromise, with both parties have settled the parental
This
limit.
is Dr. Rajasundar twice affidavit, huh?
No, my lord, 15, my lord. Dr. Sevanti Rao,
70.
page 20, my lord.
20?
20, my lord.
Signature relies on the verification just below the, above the.
Para 5, my lord. 3 lines below.
Okay. So call her.
And you will also kindly glance to evidence her deposition in court, my lord.
Some right,
21.
call her. If she.
And she is not in control, my lord.
Huh?
She is not in my control, my lord. Already declared in past, my lord. And she has already taken my lord 7
I
lakhs.
can understand she is not in your control, therefore the decree,
My lord.
therefore the dispute.
My lord.
But today, if I was, at least she should be there. I will issue notice.
My lord.
She may appear through
My lord.
also,
My lord.
or tell her to appear in VC. Both of them are doctors.
My lord.
Appear in VC, we will quash it. What is the problem?
You will also issue
You
notice.
ask her to appear in VC or I will issue notice.
Issue notice, my lord.
Okay, issue notice. The Land Council for the petitions submits that the parties have settled the dispute, and the said fact is reflecting from various documents placed before this court. Issue notice to the opposite party. Number two. In the next written only within 2 weeks. The problem is, if I give stay, then you keep on asking for adjournment.
No, my lord. That date is posted to 17th.
I want to pass it, bring them next week, Friday, Monday.
Yeah, so it's
Yeah, 7 lakh मिल जाएगी.
You try.
My lord.
Doesn't come, then we'll see. We'll quash it. Obviously, she has taken money.
My lord.
Divorce is granted. She may not be interested.
My lord.
She has made the statement that I don't want to.
My lord.
Why should it come? Make an attempt. I'll put it on 6th or 7th.
Yes.
My lord.
If she doesn't come, then we'll quash.
My lord.
Okay. But file the requisite today.
My lord. My lord.
7. 28.
Yes. May I please, Your Lordship? Yes. Lordship, this application has been filed challenging the order dated 4/12/2023 by the learned district and session judge Sundargarh in rejecting the application of the petitioner under section 391 of CRP, Lordship. Lordship, the petitioner, Lordship, an application was filed before the learned district and session judge, Lordship, for Lordship, those documents, Lordship, I am listening.
You want to mark a copy of certificate copy of judgment?
Lordship.
Certificate copy of judgment is the evidence as such.
Lordship, those we are trying to adduce the documents, but my application was rejected by.
It is a judicial order. You have taken the certificate copy. Where is that provision in the evidence act? You can. It will be taken as an evidence. What is the problem?
Evidence and this evidence were within the knowledge of the accused. And it is not deliberately not filed. But at the flag end of the trial is want to exhibit.
This matter address of
Exhibit is not required. Not required.
Certificate copy.
Certificate copy of a judgment of a court. Why have you moved the application?
Lordship, those were not considered in my case.
Let us see. Where is the provision in the evidence act? Certificate copy of a judgment. Judgment and decree. Have you read it?
My lord.
Come at 2 o'clock. Read evidence act and come. 2 o'clock, huh?
Lordship.
Evidence act. Just see certificate copy of a judgment or a decree.
My lord.
Need not be exhibited. It will be read as an evidence.
My
Read and get the judgment and come. 2 o'clock. Okay?
What?
29.
Yeah, please, my lord. You have also filed this present application challenging the order taking cognizance under Annex 3 on the ground of compromise. It is a matrimonial dispute between a husband and wife.
You settled?
Yes, your lordship, already settled.
They're
But,
there or they parted?
no. Already section 13 application was filed. In the said application, some amount has already been paid. Now they want to meet separately, and if lordship may fix up a date so that all the parties will appear and.
Okay. The petitioner has filed this petition seeking quashing up for the criminal prosecution initiated against him or them. How many of you? Against them by opposite party number 2. Petitioner number 1 was the husband.
Yes.
Opposite party number 2. Also, this dispute is arising of a matrimonial discord, and now the parties have settled their dispute. Issue notice to the opposite party number 2, written will within 1 week. Next week, 16th. Next week, bring them.
Next date may be fixed till 16. Yes.
We'll quash it on that day.
Obliged.
Bring them. File joint affidavit, Aadhaar card photocopy, and everything. Bring. Okay.
Till then, lordship may grant.
16th only. Come on 16th, we'll do it.
Obliged.
You have settled. She is not going to, precipitate the situation.
Personal appearance of the parties may be reflected in the order, your lordship.
It is a settlement. Why should a court direct? You
You
bring them online, let them appear. Why should they have a burden of a court order? If they have settled, they will come.
They will come, your lordship.
Let them come, or otherwise they can't come, then we see. Whoever may not come, they can appear in VC, no problem.
Okay.
The only problem is if the opposite party number 2 will appear in person, somebody has to identify. If she is represented through counsel, no problem. If she is not represented through counsel,
No,
then you will call IIC or the IO of the case to identify.
As per the instruction taken, Sibo Prasad Mishra will appear on behalf of the OP number 2.
Okay, no problem.
Yes.
Okay.
Obliged.
Okay.
Annexure 3 is the order of cognizance at page 24. I have challenged this order on the ground that the allegations will be, if you will take in civilian manner. It is a civil dispute. Case counter case manner. Informant filed a FIR against me, and I have also filed a FIR against her. Her case was closed on the pretext that it is a civil nature. And in this case, charge sheet is filed, madam.
No, her case against you is closed.
Closed on the pretext that
It is a civil
dispute
dispute.
is civil
Okay.
in nature.
But your case against her
Her case against me
stands.
charge
But your case is closed,
closed.
saying that it is a civil dispute. Right. What is the offenses?
You'll also be kindly first see the FIR lodged by her. That is at page 10, madam.
Your offenses are 448,
All tribunal magistrate.
329, so on so 354.
All are tribunal magistrate.
How can be 354 is civil dispute?
ଆପଣ ଦେଖୁନାହାନ୍ତି
448 is civil dispute.
448 civil dispute. ଆଜ୍ଞା ମୋ ଜମିକୁ ମାରି ଆସିଲେ ସେଟା ନା ଇଲିଗାଲି ମାରି ଆସିଲେ କୋର୍ଟକୁ
And
relating to property.
outraging is also outraging is also civil dispute.
ନାଇଁ ନାଇଁ ଦେଖନ୍ତୁ outraging ଟା ଆସୁଛି କି ନାହିଁ
Anyway,
outraging ଟା ଆସୁଛି କି ନାହିଁ ଦେଖନ୍ତୁ
your affair must be 420, 468, 471. হ্যাঁ আপনার এফআইআর দেখুন।
More FIR, you will also page 43, annexure 6.
Yes, that I can see.
506, 448, 307, 320, 427, 379.
Yes, Mr. Maharaj.
Yes, sir.
Her FIR is much more serious than the FIR against her. The cross case. Arising out of the same incident.
ଆଜ୍ଞା ସେ ଟ୍ରାକ୍ଟର ଜମି ଭିତରେ ପୁରଉଥିଲେ ମୁଁ ତାଙ୍କୁ ଗାଳି ମଦ ଦେଲି ଇଏ କଲି ସେ ଆମେ କହିଲୁ ଯେ ନାଇଁ ସେ ଜମିଟା
The FIR which you have filed,
ଆଜ୍ଞା
that is culminated in a final report.
ଆଜ୍ଞା
Where is that final report?
ସେଟା ଏଇଟା ଅଛି
Page 53.
53
Okay, 53.
সেটা তো
last part the case are completely civil in nature.
we'll issue notice, just check it up, we'll have to quash it, there is
Yes,
nothing. Issue notice to opposite party number 2, written within 2 weeks. Mr. Maharaj, the week's notice for opposite party number 1. Opposite party number 1. Returnable within 1 week, 2 weeks. Huh? 20? 2 weeks. Give it on 20th, 19th or something. Because I'm not going to give stay. I'll finish it. Yes. 19th.
Kindly grant me stay, my lord.
No, I'll not give stay. Once I'll give stay, then it will never be end.
No, end over.
You
If
move,
lordship
you
is
move up.
defeated, your lordship is that I receive that day. That day your lordship can dispose of it.
Hey, the
I
problem-
would never ask for that.
See, I'll tell you one thing. In 482, generally 482, there shouldn't be any interim order.
There should be any.
No.
That
According
should
to,
be
but according to me, you should, if you have a merit, decide it.
No, once your lordship.
Once you give adjournment, this will go on. This is a burden on the system.
Once your lordship is satisfied, time of the civil.
Therefore, I'll quash it.
That is some case. That is
Therefore,
some case, my lord.
therefore, I'll quash it.
No, in that occasion, my lord, in that occasion.
What is the next date of hearing in the trial court?
Can you also-
Give me the. I'll fix it before that. Let it be tomorrow, but
6/1/2024 ଗଲାଣି ତାପରେ ରହିଛି 23/3/2024
easy.
3/2024
20th, nothing will happen. 20th, I'll finish it up.
state and not the କାହିଁ କହୁଛି
It is in March. No question of stay.
କାହିଁ କହୁଛି
ଆପଣ ଯାହା ବି କୁହନ୍ତୁ ମୁଁ stay ଦେବିନି କାହିଁକି ମାର୍ଚ୍ଚରେ ଅଛି ଡେଟ୍.
state and
Issue notice on stay as well.
ସେଇଟାରେ issue notice କଲେ କଣ ହବ ଆଜ୍ଞା ଏଟା ତ
You come, I'll tell you. I prima facie I'm satisfied. I'll quash it. The trial court date is fixed on March. I'm fixing on 20th, 19th of February.
ମୁଁ ଆଜ୍ଞା difficulty ଟା ଟିକେ କହୁଛି ଶୁଣନ୍ତୁ
Yes, କୁହନ୍ତୁ.
ମୋର ମାନେ general difficulty is if this bench will ମାନେ there will be a change of bench
You don't want me then.
ନାଇଁ ଆଜ୍ଞା ମୁଁ କହୁଛି ଏଟା uncertain ନା
Nothing will happen.
No, uncertain.
Take it from.
That's why, my lord, if it will be listed in any other bench. कहुଛି ଆଜ୍ଞା the bench will say you have not given the past occasion.
Ma'am,
that is telling from my experience.
That's right. I also aware of that. But see, is it a consideration for a court to pass an interim order?
Because your lordship has satisfied that there is a terminus case.
The other judge will be more satisfied than you. Don't
ସେ କହିବେ ସେ କହିବେ ଯେ first instance you have not get this stay.
Anyway,
How can
I will not deviate from my standard practice. I'll give a date little later than that. Let it be on 16th or 15th. I'll quash it.
କିନ୍ତୁ ଆପଣ ସେଇ ଯୋଉ attitude ଟା ଟିକେ change କରନ୍ତୁ.
Somebody like you can persuade me sometime, then I'll change.
Professional ଅଛି
Sir,
professional interest ବି ଅଛି
that's right. Yeah.
ଆମେ ସମସ୍ତେ ଆଜ୍ଞା ସେ ଗୋଟିଏ
the
ଜାଗାରେ
problem we are facing with my lords is your lordship youth was there in Delhi, so money part never had a problem. People go to Delhi to lose cases and pay their lawyers. People come to High Court to win cases.
What to do? You have chosen this place.
So yeah, we'll go somewhere in between.
So this the emotional attack on the court.
No.
Maybe sometimes.
No, my lord, not at all.
we have better lived our life. ଆଉ ଆଜ୍ଞା କଣ ଅଛି କେଟା ହେଲେ ନହେଲେ କିଛି ମିଳିଲେ ହବ
ଏବେ ବି ଆମ ଲୟରଙ୍କ ଅବସ୍ଥା ଆପଣ ଜାଣିଥିବେ
ମୁଁ ଖାଲି ଆଜ୍ଞା ବାହାର ପାଇଁ କହୁଛି not for any other.
I understand it, but I'll quash it. Better order.
You won't argue further on that.
Shall I make it on 9th?
ଥାଉ ସେ 20 ଥାଉ 20 ଥାଉ
9th.
କାଇଁ ବେଞ୍ଚେ ଯାଉ
Serve the opposite party 9th. I'll do it.
31.
But definitely, see, the appeal made by both of you, my learned senior also.
ଆମେ ଦି ଜଣ ଯାକ ଆପଣଙ୍କଠୁ ସିନିୟର ତେଣୁ ଆପଣଙ୍କୁ
So therefore, I'll see that in the appropriate case, I'll try to do it. But I will only request that once stay is granted, don't ask for time.
No.
If you ask for time, I'll vacate it. On the whoever is maybe appearing, I'll
Yes.
vacate in the same day.
Yes, sir.
ଆଜ୍ଞା ସେଇଟା କରିବାକୁ
The whole difficulty is once you give the stay, you send your junior say that I don't have time, I am not well, and all these things doesn't suit.
ପ୍ରାକ୍ଟିସ
And prospectively you utilize from tomorrow.
Tomorrow. Okay. Okay, I'll try and match it. Okay.
31.
In this application of petition page for question of criminal proceeding, my lord, last occasion notice has been issued.
Settle. What is the offense?
307 and other offences. Young boy, my lord.
Injury report, just see. Mr. Ragada, just see. What is the injury report? You file it, injury report. Charge sheet has been filed.
Charge sheet now, recently charge sheet filed, madam.
File the charge sheet. Let us see.
My
File the
lord.
charge sheet, we'll see. Take the memo and let him file the charge sheet and place it, put it on 20th, 19th or 20th. Okay, 20th. File the charge sheet,
My lord.
along with that report, injury report.
Injury, one
And
injury.
have you implemented the informant is the victim?
My lord. In front himself is the victim.
Informant is the victim.
My lord.
No problem. Okay. Okay. Next.
May I please, your lords. The petition is challenging to pass the entire proceeding on the ground of compromise, my lord.
Yes. Offense is
Offences under section 341, 323, 294, 34 IPC, read with the 3 AC step.
POXO and then not there, na? Settlement, huh?
Yes, madam.
Settle.
Settled.
There are two cases, madam.
I am in the sub item, my lords.
Case and counter.
The other, what about the other case? What is the offense there?
Offense number 341, 294,
Same
352, 5
kind, huh? Same kind. Where are they?
My lords,
Where are they? Parties.
what is that here at Cuttack?
Call them.
We have filed, my lords, joint affidavit also.
Still you call them.
My lords.
When?
Next week, any date?
Next week.
Take-
26. 26, call them.
26th, my lords.
Yes.
They may directed to give the correct number, my lord. Wrong. Have you done?
No, these are the.
Could have.
3529.
3529.
Yes.
Case.
पुरीघाट केस के 164 है और 165.
Any confusion?
My lords?
Any confusion? Mr.
Bolangir case कर लिखे.
They are, I'll check it.
Yes.
Obliged.
Yes.
53.
My lord, I have filed an amendment petition. I have served copies. And I don't think my learned friend will object to this.
Serious objection.
It's serious objection, your lordship may allow that.
Your presence itself is serious.
So,
What is the
just a prayer portion, one line is to be added.
okay? What is the case? You tell me now. The IA for amendment is allowed, huh? Yes. Next.
So I file it by tomorrow, the consolidated page. And your lordship may call it along with the stay petition next week or the week thereafter.
Whenever,
26.
And my lord,
Actually,
I'm not passing any order. You want me to pass an order?
I see.
26,
Yes, yes.
or both the matter will come out on 26. We'll hear on that day.
My presence.
Because, yes,
My presence.
presence.
this amendment, your lordship, is allowed.
Amendment allowed.
The
Amendment application is allowed and leaves the matter on 26 along with the IA for stay.
I for stay.
IA for stay and consolidated duties. Okay.
Here I am taking your lordship, the office could direct to incorporate the necessary amendment because 2 lines amendment.
Carry out the amendment. No.
The office may carry out your lordship.
Office may carry out the proposed amendment in the prayer clause of the petition.
But in the prayer portion, a paragraph is added.
Two
So
lines.
one page is to be substituted.
That is
One
what.
page.
Let it be. We will see how does in a criminal proceeding, pleadings are not much more important. Let us see the document. She has filed the document. We'll see. Anyway, next.
34, my lord, I have taken advantage of the honorable court's order, but there is no interim petition, case was not pending. I could not take steps. I have not filed requisites for issuance of notice.
I will not say anything. Simply adjourn. Simply adjourn.
Date has to be fixed.
Date fixed. Date 26th again. Since you are there on that date.
Why I am saying, my lord, unless your lordship directs for fresh issuance of notice, office may not accept it.
The petitioner to take fresh steps to serve the opposite parties. Yes.
35.
May I please, your lordship?
Yes.
Lord, there are two matters, my lord, arising out of matrimonial dispute, my lord. On the last occasion, your lordship asked for the personal appearance of the petitioner.
Yes. Are they? They are. Okay. What is the settlement?
So we have the permanent alimony, matrimonial settled 10 lakhs.
They are separate. 13B is allowed. That's the petition. The petitioner. Petitioner. There are two petitions here.
Yes, my lord. My lord, first one is the of the wife, my lord. My lord, in that case, my lord, the final report has been submitted as false, my lord. In first case, in the first matter, filed by the wife.
Anita Gajendra.
Yes, ma'am.
Amita Gajendra and Asribad Gajendra.
Yes, ma'am.
The petitioner in the first case.
Yes, ma'am.
Here, the FIR which you are seeking quashing.
Yes, ma'am.
Final report has been filed.
Yes, ma'am.
So this is infractious.
Yes, ma'am.
Because you infractious. First, the petitioners have filed this the present petition seeking quashing of the criminal proceeding in CT case number 1. This is a CT case in PS. Final report. Just see the prayer. What are you showing me? You are talking about 2807?
My lord, I am talking about 1126.
First item is 2807 here.
Yes, my lord. Case number is 2807, my lord. I am telling about the GR case number.
GR case, what is GR case? Take out the prayer in that petition. Take out the prayer in this petition.
Yes, my lord. My lord, inadvertently it is reflected as.
That's the whole difficulty.
Yes, lord.
You neither properly draft. If the court wants to help you also, you are you don't want to take that help. What's the prayer? What is the prayer?
Yes, my lord.
How will I allow it now?
Bow down, my lord. My lord, may.
You have given some case number, CT case, something.
My lord, instead of GR.
This is a court of record. If anything goes wrong in the record, that will remain in the record. You know that?
Yes, ma'am.
This is High Court. It is a court of record.
I sincere apologies, my lord. My lord, may permit me to make necessary corrections.
Then the personal appearances will go waste. You are troubling your clients. What is this first case? Which is the FIR? 201.
Yes, my lord.
Is it true that final form has been filed in this case? 201. FIR number 201 of 2022 in PS Sadar UPD Cuttack. Final report has been filed?
Madam.
Huh? Is there? Same FIR? Are you sure? I'll record it. The petitioner in this petition, first item. The petitioner in this petition is seeking quashing of the criminal prosecution arising out of the FIR number 201 of 2022 in PS Sadar UPD Cuttack. UPD Cuttack EPD Kotak arising out of what is that GR case?
GR case number 1126 of 2022.
1126.
Better man.
Perfect. 22. Full stop. Although in the petition, the prayer is erroneously drafted, but Mr. Rogada, appearing for the state, submits that in fact, insofar as the present FIR is concerned, after investigation, a final report has been submitted on. Final report have been submitted on. When is the date?
28/2022, Malad.
28/20?
2022.
28/2022. Full stop. Next paragraph. Since the parties have settled the dispute, there is no need to pass any order insofar as the present petition is concerned. According, the petition is disposed of.
He may characterize the case instead of saying this.
The petitioner is given liberty to correct the prayer portion of the petition.
Grateful.
Next.
Second one.
Let us see.
So,
1931. Write down. 1931. The petitioner is seeking quashing of the petitioners. No? How many petitioners are there? The petitioners are seeking quashing of the criminal prosecution arising out of CT case number 2420 of 2022, arising out of Bodagoda PS case number 139 of 2022, pending in the court of JMFC 14. This is page 6, page 6 of the prayer. Full stop. The ground of quashing is that the parties have settled the dispute. The case is arising out of a matrimonial discord. The opposite party number 2. Opposite party number 2. What is Anita? Anita is opposite party number 2.
Yes,
Anita has married to Amarjit. Amarjit. Opposite party number 2 was married to petitioner number 1. Petition number 1. Full stop. After the settlement, they have decided to part away. And accordingly, a mutual divorce has already been granted on their application under 13B of HMA Act. HMA Act. The parties have now filed a joint affidavit reiterating separate affidavit, joint affidavit. The parties have now filed a separate affidavit reiterating their stand regarding their settlement. There is no dispute pending amongst them except the present proceeding. The parties are present in the court.
But two of the petitioners are not present, my lord.
See, petitioner number who? Petition number?
He not present. 3 and 4 not present.
1 and 2 are present. And 4?
4 is not present.
Petition number 1 and 2. Petitioner number 1 and 2 and the opposite party number 2 are present in the court. Present in the court, and they are being present in the court. The parties are represented through their counsels. The parties, those who are present in the court, are being identified by their respective counsel. Full stop. They have also filed their self-attested copy of their Aadhaar card to establish their identity. Taking into account the fact that the parties have settled their dispute, and the opposite party number 2 is not willing to proceed with this matter. The criminal prosecution lodged by opposite party number 2 against the petitioners in CT case number so is quashed. Yes.
36. May I please, your lord?
Yes.
Lord, this petition challenging order of learned lower court where the petitioner had called for the CCTV footages of two particular dates. The reason for calling the CCTV footages is that my lord may kindly see the date of occurrence as per the FIR. As per the FIR, date of occurrence is 21/5/2023 at 1:30 p.m. afternoon. However, the alleged vehicles and the
Yes. Yes. Not able to hear. Yes.
am I audible now, my lord?
Yes, yes.
My lord, date of occurrence as per the FIR is 21/5/2023 at 1:30 p.m. Afternoon.
What is the stage? Charge sheet has been filed.
Charge sheet has not been filed. Case is not. Trial has also not been commenced.
So let wait till the charge sheet is filed.
My lord, CCTV footage.
They may rely upon that CCTV footage. If they rely upon, they will give you a copy. If they don't rely upon, we'll see. At the beginning of the trial investigation only, you are trying to create.
Bail application they sort for the CCTV footage. Not releasing bail. At the time of pendency of the bail application, they sort for that.
Bail application is not pending. They are released on bail.
That is the order.
Try to appreciate one thing. This is at the investigating stage. If the CCTV footage they will rely upon, ultimately you are entitled to a copy of that. How do you know they are relying upon or they are not relying upon? If they will not rely upon, then we will see the relevancy, whether you are entitled to or not. Then we will verify after the charge sheet is filed.
My lord,
Only the charge sheet.
Only 2023 case, my lord. This year, my lord. They are in custody, my lord.
No, my lord. They have been released on bail already.
They are already released on bail.
Bail, no. Then, my lord, I will instruct the IO.
My lord, only concern is that CCTV footages record will vanish automatically if they are not preserved. And almost 7 months have already passed. So that is the only concern, and it is the probability of not relying upon the CCTV footages is very high because it will disclose the atrocities that has been committed against the petitioners.
You instruct the IO not to preserve it.
Yes, my lord. At least if not, they will produce. Only they can preserve.
I will just issue notice. Put it on 20th, 21st, 21st. On 21st. Meanwhile, Mr. Ragada will instruct the IO not to see that the CCTV footage are not.
Whether the same is required in this case, that is going to happen.
Let us see. But if it is destroyed, then everything, the evidence is gone.
Yes,
evidence is gone. Maybe.
I will take history regarding also up to date.
Right. 21st. Issue notice, Mr. Ragada, accept notice. I will not say anything. I am not saying anything because it is the investigating stage. I will not make any comment on that. But very well, you can instruct
about the stage of investigations, also the
and CCTV footage. But they shouldn't destroy because after 5-6 months, they generally destroy. Instruct the IO not to destroy. Okay.
Kindly fix
21st. Yes.
37.
To grant 2 weeks time for to remove the
Adjourn.
38.
My lord, on behalf of Tapas Kumar Acharya, kindly adjourn after 1 minute.
Yes.
39.
As matter is arising out of a matrimonial dispute, my lord, the matter has been amicably settled in both the husband and wife. Opposite party number 2 and the petitioner are living together. Yes, my lord. I have instructed them. They are coming within
2 o'clock.
Lords.
Yes.
40.
40, yes.
40 may please, my lords. My lord, I'm challenging order dated 1/7/2023, my lord, which is at running page number 37, if your lordships.
Yes, what is this order?
My lord, I have challenged this for rejection of my prayer under 127 3C, which is at running page number 37. If your lordship may have a glance.
Yes.
My lord, it has been stated on third last line. On perusal of the materials on record, I do not find any reasonable ground to revisit the order dated 5/8/2019. My lord, that is the initial order for interim maintenance. That is at, my lord, annexure 2. If my lord.
No, what is this? Let me counsel for both the parties are present, heard the petition under 127(3)(c). The chairperson for both the side wherein the opposite party has sought for cancellation of the order dated on the ground.
My lord, this case is
5/8. Where is 5/8 order?
My lord, annexure 2.
Yes, 5/8 order is, what is this?
Running page number 16. My lord, and the ordering portion is at running page number 20. To running page number 20, the order portion. My lord.
20, okay.
My lord, 10,000 was awarded as interim maintenance towards, my lord, the opposite party and opposite parties, my lord. In that case, my lord, prior to that, my lord, if your lordship may come to running page number 15.
You are the husband.
I am the husband, my lord.
What are you doing?
My lord, that I'll answer, my lord. Prior to that, if my lord comes to running page number 15, my lord. The question involved running page number 15, my lord, the order portion.
What is this order?
My lord, divorce. Divorce was granted.
It is under section 25.
My lord, 25 has been exhausted because, my lord, she has surrendered her rights for alimony. My lord, running page number 15. 1, 2, 3, fourth line, my lord, from the top. Before, if my lord observes it, before the court, respondent has stated that.
Where are you reading?
My lord, running page number 15.
Yes.
Fourth line from the
Yes.
top. Before the court, respondent has stated that.
Line from the top, before the court.
Yes, ma'am.
Respondent has stated that
disinclination to claim any amount towards alimony in view of their submission before this court, item wise compensation cannot be desirable. My lord, the order was marriage between the petitioner husband and respondent solemnized on so and so stands dissolved by a decree of divorce subject to payment of rupees 5 lakhs towards cost of gold ornaments and other lost articles, my lord.
Okay, this is an order
of divorce, my lord.
Divorce when? When was
divorce was granted, my lord, on 13/4/2018.
2018.
2018.
Thereafter what happened?
Thereafter, my lord, this order has been passed.
Then this order was passed on 19.
19, in the year 19.
This is on the application under section
125, my lord. And subsequently, my lord,
where does it say 125?
My lord, this is the CRP proceeding and order has been passed as per section 125, and this is an interim.
Where is that? How will I get to know that it is a order under 125?
Because, my lord, in the subsequent date has
Not
been.
because you show me.
That is noting in the item of 40 lordship.
Yes, my lord.
That is noting. Normally, to not correctly indicated in this regard.
No, my lord, that was with regard to the order. That point, my lord, last occasion
That's the problem. I am searching for that only.
Okay. You meant, my lord,
proceeding is arising from which order and under which provision?
My lord, order is 5/8/2019, my lord. The primary order, my lord.
Read, come to page 16.
Yes, my lord.
Read it now.
The order emerges out of a petition filed by the petitioner.
Under which provision? See, I am exercising 482. I should know whether alternate remedy is there or not. If there is an alternate remedy, 482, I can't entertain. You would tell me.
My lord, this is not what I am challenging because this has been challenged under RPFM, my lord. 19
you moved an application for recall. Recall is rejected. That rejection you are challenging.
My lord, rejection. Why I am seeking, my lord, your lordship may have a glance to 125(3)(c). What does it state?
First of all, it is under 125 or not, that is yet to be,
My lord, this is an application.
ascertained. Anyway, 125(3)(c), let us see what you are saying. 125.
3C. The woman
Okay,
has
1 minute, 1 minute. 1.25, 3.
C.
C. Mhm. Where is that one? Read it.
My lord, the woman has obtained a divorce from her husband and that she had voluntarily surrendered her rights. The word is, my lord, voluntarily surrender her right.
Again, you are entering into merit.
My lord, I'm not a.
You
My-
may have a good case, but
my-
whether 482 is
My lord, 482 can be.
maintainable or not, that is the question.
My lord,
Whether
this
an
is an
alternate remedy is available to you, you have to file the alternate remedy.
My lord, alternative remedy, my lord, 125 against 125 order, my lord, I have challenged under 19+4. That is at annexure 3, my lord. That has been exhausted, my lord. Subsequently, my lord, I had filed an application under 127 3C for cancellation of the interim maintenance order, my lord. And my lord, that order was rejected, and for which I am before this honorable court in 482. My lord.
I'll simply issue notice, let us see.
My lord.
Issue notice the opposite party note.
My lord,
No stay.
obliged, my lord.
Because it's whether it's maintainable or not.
My lord, my lord, my lord.
No stay, let us hear the other side.
Yes, my lord. Obliged.
One.
May I please, your lordship?
Hmm.
Petitioner, in this case, your lordship, challenging the order of NBW issued against the petitioner at annexure 4, your lordship.
When you got the bail?
Lordship, the bail is, it is not the bail. I am absconder, your lordship. I am an absconder. I do admit I am an absconder. I approach this honorable court, anticipatory bail. Then
Rejected.
no, not rejected, your lordship. I have the copy of the rejected, but the protection has not been given. For that reason, I have not surrendered before the court below.
When are you going to surrender?
Lordship, 2 weeks given me, I will surrender, because reason being, your lordship, the section 32 VA is
Your 438 is rejected.
no, not rejected.
It's pending.
Allowed, but protection has not been given. That is the problem.
Allowed what protection not? What is it?
Surrender and surrender, Khali.
Won't surrender. Why are you coming here?
Sure, reason being.
No.
So, lordship,
There is an order, warrant is issued. There is an order.
Yes, your lords. I do admit.
You don't go, obey that order.
No,
Now you are coming for it.
No, lordship, for a moment, I draw your lordship's kind attention. The same person filed 2 affairs against me.
On merit, I will not.
Lordship,
You have gone to 438 court. 438 court says that go and surrender. You don't surrender, NBW is issued. And 482.
NBW issued earlier NBW.
Obviously.
Charge sheet submitted showing me
Give me
absent.
that 438 order.
Yes, your lordship. That is
Give me that 4.
only reason is that there is no protection. So for that reason, I will.
They will not get.
I will all the paraffin.
Why should they? Then you go ask for modification. By way of this petition, the petitioner is seeking quashing of order dated 22/8/2023, passed by Lieutenant District and Sessions Judge, come Special Judge, so and so, page 7, whereby NBW against him has been NBW against him has been issued. Then counsel for the petitioner submits that he had approached this court by filing ABAPL number 16607 of 2022. The learned coordinate bench by the order dated 4/1/2023 directed him to surrender before the court below.
If no case, the court consent shall be influenced. The observation. I will surrender, your lordship.
Surrender before the court below and seek appropriate remedy under law, available under law. It appears that he has not complied with the direction of the coordinate bench. Rather, he has approach this court under the inherent jurisdiction. In the inherent jurisdiction. I'm of the view that inherent jurisdiction, full stop. This is not fit case for interference at this stage. The land counsel for the petition submits that he will comply the terms of the order dated 2020, order dated 4/1/2023, passed by the coordinate bench in AVAPL number 1601. So,
And the land trial court shall do well to consider this. Only that line, your lordship, only that.
don't try to
Yes, your lordship.
shortcut. You try some other court, you didn't get relief, so 482, what is this? Go and surrender. You have got an order.
Yes, sir.
To comply that order. Yes.
Obliged.
42. Matter relating to matrimonial dispute. In the meantime, the matter has been amicably settled between the
Where are they?
lordship and the environmental lordship. No, the first time this has gone.
Each notice to opposite party number 2. Opposite party number 2. They started staying together.
No, lordship, but they were settled to residing separately. And that.
Mutual divorce and everything is
ନାଇଁ
granted.
ସେଇଟା ସେମାନେ କିଛି କରିନାହାନ୍ତି ପ୍ରଜାପତି ବ୍ରହ୍ମକୁମାରୀ ପଳେଇ ଯାଇଛନ୍ତି ସେ ୱାଇଫ୍ ପଳେଇଛନ୍ତି ସେଥିଲାଗି ତାଙ୍କ ଉପରେ ଡିସାଇଡ୍ ହେଇଛି
The land counsel for the petitioner submits that the present dispute is arising out of a matrimonial discord, and the parties have now entered into a settlement. Let the settlement. File joint affidavit and
lordship till then
he seeks time to file joint affidavit, and also seek for an adjournment so as to enable his client to appear before the court. State of 27.
lordship till then no correspondence lordship
Settlement, who will take courtship action?
नहीं से जो
Then you are doubting your settlement.
man question number 2
Who will take courtship action? Your notice is with you now.
policy no correction lordship
Did they see?
Here also, there has been
50.
43.
Yes.
Here also the case has been settled between the parties and I have taken a specific elaborament. First time it has come, I have issue notice, direct me to appear any day, next week.
Medical?
Medical, I'll come with that.
Mr. Manas Chand, the advocate appearing for the petitioner, submits that the parties have settled the dispute. And he wants to place on record the relevant documents.
Yes.
Relevant documents. Issue notice to the opposite party number 2. Opposite party number 2
and 3. Who is the
victim and informant. Opposite party number 2.
Injured, victim.
2 and 3. 2 and 3. Returnable within. Oh, short date there. 50.
Short date the 50 register instead of issue notice, may say come after on 7th or evening. 12th,
12th.
Instead of issuing notice, may say only because if I will submit the registered post, it will go and it will take some time.
No, 12th I am fixing. If notice, meanwhile notice, let the notice go. If they come, ignore the notice and proceed. What is the problem? You come with the injury report and all.
Injury report and settlement. That is
settlement. Even if notice is not issued, if they are there, we'll finish it up. Yeah.
One IA is there.
Issue notice on the IA as well.
No
Settlement what say?
Police said band ho gaya kichla apho
No, band ho
so case and counter case, not that one case.
That's right. 12th time. 12th time. Yes.
44, my lords, the prayer of the petitioner is limited, my lords. He made a prayer before the learned court below, my lords. While granting bail, he had to surrender his passport, my lords. Now, my lords, we'll see page 63, the order, impugned order. I prayed for issuance of my passport for renewal, my lords. My passport has expired in between. I want to, and in past also, there have been orders for me for release of passport. I have gone outside, I have come and I have surrendered. Now, my lords, my passport has expired. I want the issuance of passport for renewal of next 10 years. the court below is not
You ha-
granting.
You had moved an application.
Application, my
Where
lords.
is that order?
My lords, order is at page 63, my lords.
16.
63. Order dated 16/8/2023.
53. Okay, what does the court say?
The learned counsel for the petitioner submitted that the original passport of accused Dharendra Kumar Khandelwal has been deposited in the court and his passport is valid till 29/11/2023. Prior to 6 months its validity, renewal of passport is necessary for the purpose of visa. Further, it has been submitted that the accused petitioner is required to obtain permission from this court in terms of office memorandum wide GSR number so and so, Ministry of External Affairs, Government of Odisha, for renewal of his passport as criminal cases pending before this court against him. It has been submitted that the accused petitioner, being the managing director of E Square Systems Technology Private Limited, having partnership with different technology companies across the world, for which it is required to attend different conference, workshops and training programs across the world. Besides this, E Square Systems Private Limited, dealing with technology solutions and services, business of which is necessary to visit outside the country for business commercial purpose. Therefore, renewal of passport is highly necessary. Unless the operative part is at last paragraph. Peruse the case record, submissions of both the parties. It is found that no material document has been submitted by the learned accused petitioner regarding his visit to US in near future for promotion of his business and also to attend training program. Accused petitioner is facing trial in this.
You have valid visa to US.
Well, that's my passport. If I don't renew it, my visa I cannot get it. Man. The passport I
You
have to
must be
get.
having the visa for long time.
I want to apply for visa, my lords.
No, your visa is expired, long term
Yes,
visa.
ma'am. The
USA.
passport is, I want to renew my passport for 10 years.
What is the impediment?
My submission, my lord, first time this are listed, my lord. Name of the Mr. B. Bhuya may be record in the cause list, and 1 week time may be granted to obtain instruction, my lord.
But what is the impediment?
Let me, another,
These are
I am praying for only 7 days time for
the
instruction.
constitutional right to have a passport and they want to renewal. Do you have, you are not making a statement that if there is a flight risk.
No,
I
that,
can understand if there is a flight risk, then you can prevent or something of that sort.
No, that
He's the supplier of all
Case
these.
renewal only.
The lordships, he is the supplier of all these computers. That is before your
You
lordship.
take away then your court.
I have my only 7 days, that I am.
I'll give a short date.
Yes, yes, short date.
Let Mr. Bhuyan's name be inside.
My lord.
A renewal of
Yes, yes.
unnecessary.
Only after short date.
And you just seek instruction whether there is a flight risk.
My lord.
And he says that he had availed the passport, went and came back out.
Yes, my lord.
Yes, sir.
53, 54.
Supplier of computers to the High Court, if he is a flight risk, I have nothing more to say. That's okay.
Seven.
My lord.
45.
Seek a positive instruction.
My lord.
Don't oppose for.
No. Questions.
Small.
And my lords, all the, in a criminal revision, all the sections have been quashed except 120B. There is a judgment of the Supreme Court, my lords, 120B cannot stand in isolation.
I need not go into all this.
No,
Simply-
that's a separate.
Simply you want a renewal.
Yes, sir.
6 months prior to renewal of the passport is required. And when you will travel and then you seek permission, whatever that is.
Yes, my lords, the allegation is I have supplied computers to a chit fund company, my lords. How do I know whether a company is a chit fund company or not?
That's why on merit you may be having a case
my
or
lords.
not that.
Deeply obliged.
45. 45 your lordship, some defects are there. I will remove by this week. Your lordship may be taken up.
Adjourned.
46.
Same prayer, your lordships. Same prayer, your lordships. Urgent this, I will remove the defect.
Adjourned.
47.
My lord, 47, kindly, my lord, tomorrow.
Yes.
Tomorrow, I frame it tomorrow.
Tomorrow may not be possible.
Day after, my lord.
I will accede to your request, but date will be fixed according to.
Yes, as your lordship.
What is happening is I am trying to fix particular
Your
number
lordship,
of
keep
matters.
it to
If it is
Passover.
unnecessary urgent, then you know.
No, my lord, lordship, keep it to Passover. My lord, Passover, I will come. and
Passover you argue it.
little
Yes.
Passover, kindly.
Yes.
47.
47 karo na?
48.
And my lord, Passover, yes.
Yes, Passover.
My lord.
My lord, on behalf of Mr. P.S. Singh, my lord, may I be permitted to submit?
Yes.
My lord, I mean, the action of the opposite party has been challenged by invoking your lordship jurisdiction under section 482. My lord, an FIR has been lodged in IPC and as well as in MS special statute, it's the MMDR Act, your lordship. Which the law doesn't permit to registration of an FIR because then apex court judgment also regarding that. The two, because MMDR Act is special statute which is prevail over the IPC.
Charge sheet has been filed.
Charge sheet has. No, I am not. I am not.
Has the charge sheet been filed?
That state has to give an instruction for that.
Investigation is going on.
No, I investigate my lord. They cannot do it. I am just saying to my lord.
No, they may be they dropping this, saying that we don't have this thing. How do you know?
He has not.
They may write 1,000 number of offences in the investigation.
My lord, they cannot initiate. My lord, they cannot initiate 379 and 21. My lord, may kindly see have a look on the 20
I'm
in the MMDR Act.
I'm accepting it to be correct.
My lord.
But how do you know that they have started, or how do you know? In the FIR they may write whatever, but investigation they have to carry out, and the senior officers are also there. They may say that the 21 section 21 we can't investigate, and they will drop and file the charge.
Let them give an instruction on that because they have to take an instruction because see they cannot. I'm not in a bail. I'm not seeking any bail for these things. Why should I give a certificate for this? Isn't true. I am invoking your lordship for passing of an FIR.
What Mr. Maharaja is saying is, if you don't give that kind of declaration, recently there was a problem.
Recent judgment by the Supreme Court.
There is a problem. And what happens is, in a criminal proceedings, the judges don't read the pleadings. If you don't disclose it, it escape notice. And there are a lot of problems there.
Error, my lord. I will just.
You know recently what had happened.
I know.
But that is so therefore the objection which he is taking is a serious objection. Otherwise what will happen is, it is a reflection on the part of the prosecutor. Why has he not pointed out?
And he has pointed out.
Yes, I know. That is the reason the seriousness.
I understand that is, but this is
genuine.
I am challenging because the action has been challenged over here. Because I understand your lord.
You came to the court.
Yes, your lord.
Then your duty to disclose.
I'll.
And the bar should be alive to this fact. Because either you will be in the problem or they will be in the problem.
Mile. So let them take instruction on this so that
you do file a perfect petition so that we will see.
It's the investigation case. It is premature.
My lord, it is. How can it be? It says that their action is illegal. How can they invoke the initiate an action? My lord, may kindly see. I will look on the thing.
Where have they invoked?
My lord, may kindly see.
When you use the expression, they have invoked. Where they have invoked?
My lord, may kindly have a look on the FIR.
FIR, registration of FIR is invocation of a section.
At a premature stage,
see, somebody comes and says that this happened, that happened. They registered the FIR. And
therefore there's an answer
thereafter they file the charge sheet, then you say
my lord, what happened, your lord? In the MMDR Act, if they will go, they cannot initiate a lodge an FIR. In MMDR Act, a complaint case has to be filed. And in 379, then FIR has to be lodged.
When in the charge sheet you will
be
Mr. Dwivedi
by the central government or the state government, authorized by the state
government. You have an authorization.
Mr. Dwivedi, I'll tell you, you will be pleasantly surprised when the charge sheet is filed, this section won't be there. To wait till then. To be pleasantly surprised. Okay. So no, it is a premature petition. Wait for that. Will you withdraw or
if your lordship will say that I'll permit to insert these things,
no, better you withdraw till the charge sheet is filed. It is a premature petition. Why you keep it alive?
My lord.
That's a better idea. Mr. Dwivedi, Learned Counsel for the petitioners, submits that he in the FIR, section 20 of Mines and Mineral Development Act, so and so has been alleged against his client. He submits that the state police cannot investigate the offense in regard to the DRA. Full stop. Next paragraph. Since the FIR is at the investigating stage, it seems the petition is premature. Therefore, he fairly concedes the position and seeks to withdraw the petition, reserving his right to challenge at the appropriate stage, if need so arise. If they drop it, then you need.
No, they can either prosecute me in the 379, that they can. But 21 cannot, because the bar is there in the 22. They cannot.
That's what I'm saying, that you will be pleasantly surprised that provision won't be there in charge sheet. Therefore, I'm
Pleased.
49.
May please, Your Lordship. But here the petitioner filed his 482 application for quashing of FIR under Annexure 1.
Yes.
The FIR is, my lord, offense under Section 52 of Odisha Excise Act, my lord, and 34 and 120B. Not here, the allegation is that in the two Maruti van vehicle, the foreign liquor were traveling, and
what is this annexure 2?
Well, annexure 2 is the order sheet of the entire order sheet, where, my lord, so it shows that final form has not been filed for last 2.5 years. My lord, it is an offense of 3 August 2021. Last order I have given 24/8/2023, awaiting final form. Page 19 of the annexure 2.
So what is your grievance then?
No, grievance is that
Non-filing of the
no, my lord. Here 52 has not been made out against me. My lord, here I am a authorized salesman of a foreign liquor shop. Allegation is that I, on my advice,
let them investigate, and the 52 may be dropped also. How do you know?
2.5 years they are sitting over the matter.
What is the stage, Mr. Maharaj?
August 2021. Now it's December 24.
This is a fair case, and this application is filed, and your lordship may want to draw your lordship.
I'm simply urging it, seek instruction.
Subject to correction, my learned senior. No certificate has been given. First or second order has been passed.
I have stated. My petition I have stated.
And ABLPL number 982 of 2020.
Para 14 I have stated. I have not suppressed. I have stated.
Certificate plus.
Certificate has not given it inadvertently, but I have stated in para 14.
The certificate, see, these are the requirement to,
Yes, Lord, I understand. Just now it was discussed.
Better that one should do it.
Yes. But I have disclosed, Lord. I have not suppressed.
You have disclosed that, but certificate also you should give. Meanwhile, he will seek instruction.
Yes.
Let us see.
Yes.
And,
Okay.
You give the certificate where I'm just
Yes,
telling it to, let it be on 13th.
I am taking instruction regarding progress of investigation.
Yes.
That is only his grievance.
Yes.
You do this way or that way.
Yes.
Start doing something. Note it down and do it. I'm not saying anything.
Date
16.
No coursive action. Till then. In interim lord notice may be issued.
You failed there and you want 482. 482 is something different.
No, Lord, here no doubt, Lord. My van has been utilized by the driver.
Again,
where Lord, I am involved.
Earlier also said the same thing. You will be pleasantly surprised.
If that will come, Lord.
See, I can understand. If
here it is a case of 52 blood.
If you have not attempted for bail, you are attempted for bail.
Yes, not that admitted fact. I have stated.
So what is coercive action? Coercive action is such a dangerous sentence.
Yes.
In a FIR quashing that tantamount to stalling the investigation, which no court has jurisdiction.
Yes.
No, 2.5 years.
Very casually, you can't say no coercive action.
Lordship, see the action of the police. Here, 2.5 years, they are not giving 52.
That is the reason
in a case, excise case, they are not giving charge sheet.
That is the reason.
Thank you. I'm going to ask control. Again, I got a vehicle that's included.
No, they had first or second.
That owner of the vehicle has not been included.
He's a absconder.
I know there are many things need not be said.
It
is understood. And he understands more than all of us.
Obliged.
Yes.
Please,
This is arising out of a vigilance case.
Yes,
You
sir.
remember that case where locate order.
Yes.
That I'll also look to the last order which was passed on 12/1/2024. If you also come to page 62,
For hearing on the
page 62, the locate order, which has been stayed by this court. Page 62, the order dated 13/1/2023.
62.
Yes, sir.
Yes.
Also see the order dated 13/1/2023.
Yes.
And you'll also come to the page 60.
May I submit, my lord? I have supposed to file the objection affidavit, and I could not supply the copy because there is no address, no phone number is given in the petition, and there are so many facts and significant facts. Earlier filing of the case has been suppressed, and the order has been obtained in the writ petition. I have I have addressed everything in my writ petition.
You have every right to file your objection, but don't make any aspersion against somebody that phone number has not been given. I was appearing on that day, you yourself had appeared. And you know that. It is very unfortunate. Don't say like this.
The reason is that I could not file the counter.
That is a different thing. You have a right to file an objection. And no objection.
These are neither here nor there.
Yes, sir.
ସକାଳୁ ବି କହୁଛି ନେଇଯାଆନ୍ତୁ କପିଟା
Since a senior counsel of his
No, no,
station is appearing,
I am not.
don't make those kind of.
I have all respect, all due respect towards
Give a
my
copy.
senior.
Give a copy. Let him have the advantage of
Junior ମୁଁ ଫୋନ କରିବି କହୁଛି ସେମାନେ ସାରଙ୍କର କିଛି କଥା ନାହିଁ ସେମାନେ they are not accepted.
Second को fix up. Also look to the last order. Second receipt.
I know you framing of charge.
And second itself matter has been posted. Same order.
Same order repeat. 12/1/2024. Same order. Interim order. Super. Then counsel for the Paratita. Or agree?
Your lordship
Give it
में-
it. And he has filed the objection. Copy of objection given to him. Okay.
And
And my learned friend has no right to say suppressing the fact I have obtained the order from the read court.
Everything that is there on record.
Your client has said, and you have also disclosed it here. Let us see that.
Let us say.
I have suppressed. Let us sign an affidavit.
I am given you by affidavit.
We will examine that.
Lordship can listen.
No, we will examine. Why? Do you want
Yeah,
hearing?
in course of hearing.
He will examine that also.
Let him hear. The lordship.
He has every right to make his submission in that particular court, that assigned court. You have every right to vacate the interim order. But so long as the interim order is there, you have no right to say like this.
In 482, earlier 482 that has been disposed of, that
All right,
was
you have-
not
you
brought to the
reserve
notice
your
of this
argument, you will have-
honorable court. Had it been brought it to the notice of this honorable court?
If you are correct, then they will face
That
the
is it. I am
consequence.
not on merit. I am ସେଥିରେ ନାହିଁ ମୋ କହିବାର କଥା ହେଲା it's so many accused persons are there. Your lordship may keep it to some other day if your lordship is adjourning it.
That's what you have given the copy. Is I'm fixing
So
a
that-
date.
It can be hard and disposed of.
On
It's matter-
27th of February.
27th of February, I have some personal difficulty.
Yes.
Can it be on 28th?
Okay,
Yes,
no
no
problem.
problem.
20. No
Much
problem.
obliged.
20.
The interim order. Same.
Interim order, same.
My lord, may I pray?
Even my lord,
So let,
question of criminal proceeding, my lord, on the ground of compromise in a matrimonial case, my lord.
51. Okay. Yes.
Passing of criminal proceeding on the ground of compromise matrimonial case under section 498, 323, 294, 307.
They are there, present.
No, my lord. I did not want date may kindly fix, my lord. Both will be
The
present.
counsel for the petition submits that the dispute is arising out of a matrimonial discord, and the parties have settled their dispute outside court. Next, issue notice to opposite party number 2, written within 1 week. Mr. Maharaj appear for the state and waives notice. Date is 15. Short date is 15. 15.
15, my lord.
Joint affidavit file karantu.
Yes, my lord.
If you can bring them.
Yes. 52.
52, my lord, the case of Belgium, my lord, but I pray for 1 week time, my lord.
Why?
I have no specific instruction when the accused has surrendered before the trial court, my lord. There is a order. I also annexed it, my lord.
You are on bail.
I am on bail. Kintu kebbe se surrender kala, that is not in.
No, I give a date to go and surrender.
No, my lord. Khale
See,
saptah time.
he is not sure of the date of bail.
He has granted
Whether
bail,
he
my
has
lord.
been granted,
When he has surrendered, I have no certified copies. So for that reason, I am praying for 7 days time, my lord.
No problem.
Next week, my lord.
Otherwise also you can give an undertaking and let him surrender. I'll go.
Yes, yes.
Watch it and pay the cost and finish.
Yes,
Isn't
my
it? Why to waste another hearing?
that you
What do you
also
say?
observe. Petitioner was on bail.
No, petitioner was on bail. That's what he says. Petitioner was in bail, but he jumped the bail.
Yes.
So therefore NBW issued.
Yes.
Now he undertakes to appear on such and such day.
Yes.
Whatever. And subject to, when will you appear?
Within 7 days.
On or before?
Within 7 days.
Within 7 days. 7. Huh? 7. No.
Many cities.
Dispose.
1,000 cost. Within 7 days,
Bar
he,
council. I'm a bar association.
counsel for the petitioner on instruction submits that his client will surrender before the court within 7 days from today. On the basis of the aforementioned fact and submission made at the bar, the order dated, which
Desi Chari Baisi.
order dated so and so is cost, cost subject to the petitioner paying cost of rupees 1,000.
Obliged.
53, your lordship, there is some defect, your lordship. I will remove by this week, your lordship.
Okay. Adjourn.
54. Here, the offences alleged against the present petitioner is section 373, subsection 3, 417, 120B of the Indian Penal Code and 25 of the Interstate Migrant Workmen's Act 1979. Last occasion, I had supplied the license copy, wherein, if your lordship will kindly see, I have been registered to supply to the government of Telangana, of the Labor Department, supplying 100%.
Let us see the allegation.
Yes.
What is the stage of investigation?
My lord? No, so far the investigation is concerned, I don't have any copies. My friend has annexed whatever the copies are there, the FIR 161 statement.
Yes, investigation is
And
not
apart
closed.
from that, one
What is the
anticipated bail.
allegation?
Anticipated bail
His
also.
only case is, it appears that he has license. So license doesn't mean that he can, on the garb of license, he can.
License and anticipated bail has been rejected. First or second order
What
was
is the
passed.
allegation? See the allegation.
That is reflected in page 20, page 20, I
First
think.
come to page 9. Page 9, Mr. Bose. Read.
Yes, ma'am. With reference to the subject, the such and such, on inquiry as per the direction of the IHC Joint Chief, along with such and such, detained the train Puri Sidri Sai Express by help of GRP Police Courier, and on being asked to the passenger of the last two general bogie of Puri Sidri Sai Express, they disclosed their name and address and listed in a separate seat. During inquiry, it came to know that the labor sardar, namely Abdul Sajid Khan, who is petitioner before your lordship, has paid advance money of different amount to the listed laborers of different villages of district of Balangir to engage them at Hyderabad at different brick links, alluring them to get heavy financial benefit. And today, Sardar Khan gathered the laborers in Kontabanji railway station and trafficked these laborers to train to transport them to Hyderabad for their engagement in different hazardous jobs in various sectors and put them in physical and financial exploitation. This is the allegation. But the first line shows they have been paid advance to get more benefits. So, my lord, these two lines are contradictory to each other. And I have provided that I have given a license, that license is there that he can take 100 workmen. So once I have a license, my lord, the question of cheating them or trafficking them does not arise.
What is the statement and 161 statement?
Yes. That is in
because
Durga
the
Prasad.
FIR doesn't make out a case, because FIR says that some money was paid to them and promise that once you go to Hyderabad, we will pay heavily. He will pay heavily. And in between only you apprehended.
Yes.
So if they would have gone to Hyderabad, if the money is not paid, then the question of cheating arises. Okay, this is one aspect. The only thing is some money was paid, that is accepted by the laborers. And they say that last line, on verification from the labor, it is learned that labor Sardar has given them some money as advance and promised to pay the heavy amount on reaching the destination and cheated them for harassment at last. They have not reached the place, that is, they have not gone to Hyderabad. In between, in Kantamanji, they were arrested. And after, how will you contemplate that once they go to Hyderabad, they would not have been paid, they would have been tortured or whatever?
The statement has been recorded.
This is the apprehension only. So therefore, as per the FIR, no case is made out. Let us see 161.
Statement has been recorded. The victims, those are the laborers. Durga Prasad Satnami. Labor Sardar Abdul Sajiz Khan, alias Papu alias Kapu Khan, मोते कहिला हैदराबाद रे इटा तैयारी कले अधिक पैसा मिलिबो कहि हमकु ठकी अधिक पैसा रोजगार रो लालसा देखाई निज फायदा पई षडयंत्र करी किछि पैसा देई गंतव्य स्थल रे पहुंचिले अधिक पैसा देबु बोली कहि कंटाबांजी रेलवे स्टेशन रु पुरी शिरडी साई एक्सप्रेस जिबा पई कहिला मु ता कथरे लोभरे पड़ी सकाळु मो स्त्री दुलारी सनातनी ओ चारि छुआ सहित कंटाबाजी स्टेशन को आसिली सेठारे आहुरी मो पुरी अन्य ग्रामर लोक माने मध्ये उपस्थित थिले मु सेमानकु पचारिबारे जानिली जे सेमानकु मध्ये लेबर सरदार अब्दुल साजिज खां किछि पैसा प्रलोभन देखाई इटा तैयारी करिया पय हैदराबाद रु पुरी शिरडी साई एक्सप्रेस रे पठाउची जेहेतु आमे लेबर लोक तेनु लेबर सरदार माने आम मानकु ठकी टंकार प्रलोभन देखाई अन्य राज्य को पठाई थांती किंतु कोनोसी कागज पत्र आम नाम रे करि नांती कि आमको कोनोसी सरकारी कागज पत्र देई नांती सेमाने एई परि आम परि निरीह गरीब लोकंकु टंकार प्रलोभन देखाई डकाई धमकाई सेमानकर स्वार्थ साधन करी बड़ लोक होइतांती आम ग्राम को लेबर सरदार अब्दुल सजीज खां सोआनसो किछि दिन आगुर आम ग्राम को आसी मते आम ग्राम लोक मानकु अन्य ग्रामर अन्य लोक मानकु टंकार प्रलोभन देखाइथिले ओ कहिथिला हैदराबाद को इटा गढ़ी गले सेठारे भल पैसा मिलिबो तेणु आमे ता प्रलोभन रे पड़ी जाइथिलु ओ तांको अनुसार पुरी शिरडी साई एक्सप्रेस रे बसी करी जाइथिलु ओ आमे रायपुर रु ट्रेन जोगे आमे हैदराबाद जाइथिलु आजि
you read that if Hyderabad they have gone then
जाइथिलु तापर बसी जाइथिलु ओ आमे रायपुर ट्रेन रे जोगे आमे हैदराबाद
1 minute
जाइथांतु आजि जोंको थानार पुलिस सर माने आसी ठीक समय रे पहुंची खरियार रोड रेलवे स्टेशन रे हमको उद्धार करी हमको थाना को आनिथिले
then where is the cheating? Then they have promised that they will pay, and if payment is not made, then the case is made out. If the promise and in between only you cash them, and they this is only contemplation.
Presumption is
if they would have gone there, they would not have been paid. They would have been tortured and all.
Presumption is there, Milord. Had
How
they
will you
been
presume?
not rescued, had they been not rescued,
Rescue then
definitely they would have been taken to that
but
destination.
on the basis of a license.
License, they could not able to provide the license, produce the license. That is the investigation. And they subsequently, when
Let
the
us see-
application
let
has
us
been
see the
filed,
cha- let us see the
you
charge
also
sheet.
may kindly see, this application has been filed without any license, right? Now the license has been produced with the supplementary affidavit.
Let us see the charge sheet whether during investigation have they produced.
Charge sheet has been not kichi deina ante
Bring the charge sheet.
kichi deina and this matter has been argued in before this honorable court, and for this court has not satisfied, not granted anticipatory bail, and first or second order has been granted in favor of the petitioner, and 21
No, that's
21
not the
days
case.
was given
No,
to
Mr. Bose,
surrender.
try to understand what he says is, if your entire case is hinges upon a particular document, if the document has not seen the light of the day, whether the document is false document, right document, wrong document, that's what I want to know, whether you have produced that thing before the police or not. If you would have produced it, they would have checked the veracity of that document.
Let them take instruction on my document.
You
My-
file
my-
just
my prayer, my lord. I
otherwise
will take it.
from the allegation.
Yes, your
No
lordship
case
is rightly pointed out. But the question is, this point has been raised before this coordinate bench. And this has been argued. Court not satisfied. Court
Where-
not
where is that-
granted.
where is that order of High Court?
Your lordship may kindly see.
I have annexed it. I have
That
not
is there in
One
page
minute, one
33.
minute,
No, I am not saying say suppressing. Page 33. He has annexed.
Yes, I have annexed.
Your lordship may kindly see.
Where it was,
Elaborately discussed.
the court only said that first hour, second hour, within 21 days, you move.
Let us see what
the
your argument is. Let us see. You stated that to party. However, on the submission of the council, the petitioner is giving liberty to surrender report. What about the earlier bail application? 12498.
Did a bail application.
Where are those orders?
No, that was withdrawn as dismissed. That was withdrawn as dismissed.
Then this is the third application.
No, please don't say that it's a third application. It's
Why?
a 482 first application.
This is the third
Bail-
application
bail
so far the
application
petitioner is
cannot-
concerned.
Correct.
This
See,
is the third application so
first
far the
bail
petitioner is
application
concerned.
you
Don't say
withdraw.
what-
I
don't
withdraw.
say-
That is 28 October 2021.
Yes.
Thereafter, second bail application
Second
is this.
application, this is the order.
This is the order, and this is the third attempt. That's what he says.
Attention in 482, that stating that
See,
the no case is better.
I tell you, in reading of the
I could not-
FIR and 161 statement indicates that the offense would have happened
Could have.
if you would have gone to
So,
Hyderabad,
now-
not paid and all. But when the police apprehended these people, arrested these people, you are taking them.
Yes.
Police might have asked, demanded you the
Provide the
license.
authenticity. Provide the
I was
authenticity.
not there. That is the reason. If I would have been there, my lord,
You
I
escape
would-
you.
if I would have been there, I would have been arrested on the spot. Because I was not there, their laborers were there. I was not there. If I would have been there, I would have been immediately arrested because with the 120B, 373, all are life imprisonment punishments. I would have been arrested then and there. So, my lord, once I produce that material that I have got a license, State Council may take instruction from the police whether the police has
No,
taken.
one. My lord, this
You file the
same
charge
council-
sheet, let us see.
My lord, kindly see for a moment. The same council, this plea of argument has been raised before this honorable court.
We
And
don't
the
know.
same plea,
My lord, how?
And the same plea-
One minute.
Arguing?
1 minute, let us see, understand.
because the
See,
council
nothing
is
is
the same.
Many things can be said in open air. That this was the argument. This same council had argued this. Can the same council?
Can you say you are not the council so far the anticipatory bail is concerned?
Who says no? My name is not. Can I say no?
If you argue amongst yourself, it's better that go outside and argue. That's a better idea.
My lord, if-
And whoever has a better voice, he will dominate the other.
My lord, if certain things are
What is
said,
it?
it is not
See,
acceptable.
I expect senior counsel of your stature should maintain decorum of this court.
Absolutely, my lord. If-
Otherwise, please don't appear in my court.
my lord, my voice may be little louder, but once.
So, the court is asking something, you have to answer it. You
No.
are arguing, cross
My
argument.
lord, if things are placed unpalatable, then I have to answer.
Mr. Maharaj submits that the matter is at investigating stage, and he would seek instruction regarding the stage of the investigation. And if the charge sheet has been filed, place the copy of charge sheet before this court by next date of hearing. Give it on 20th or 21st or something.
I'm sorry, my lord, if my voice has been misunderstood, I'm extremely sorry.
This is not expected from any lawyer in the court.
My lord, if things are unpalatable, things are placed, my lord, I have to resist it.
I never said any.
Anyway, no further precipitation.
But maybe pardon, my lord.
Because lunchtime you should have peacefully lunch.
My lord, maybe
The intake will be more now, both of them. They have more. Because they lost their energy by shouting.
We'll also supplement more because of this.
maybe pardon, my lord.
Very.
My lord, item number 63 in this case, my lord, already compromise has been effected. Lordship may fix a date so that both parties can appear. Matrimonial discord between any date, Lordship may direct.
Right, Friday.
My lord,
Friday.
Friday from Keonjhar it is not possible.
Then
On
Monday, Tuesday, Wednesday, when?
Wednesday, my lord.
Wednesday.
Wednesday. Wednesday is 7th.
7th.
My lord. 63.
Item number
63.
58, madam. Item number 58, madam.
Hmm.
On the same occurrence, madam, 3 cases has been registered. That has been challenged, and Son Court has also taken note of that Priyanka Srivastava. Because in the complaint case, he has to give a specific affidavit indicating that previous all the disputes and whether he has approached the court. The Son Court has kind enough to grant the stay. stay order is operating till date, my lord. May it be taken note on 12th, my lord.
That's the whole difficulty. Stay is operating.
Yes, I have
And
said
it's
so, I have
taking-
said so, my lord.
May I please lordship, item
After that
50.
we'll see.
50.
Aye.
Very good.
Oh, why not?
See,
Apna
No,
thoro
no,
time
that's
nahi
all
chal.
right.
then
After.
well, stay once you
Sorry, sorry.
if this
Sorry.
that's the
Ah,
problem.
exactly.
All right.
Anyway, you want to mention something?
55.
Pardon?
Yes.
My
on
lord,
page.
item number 62.
Huh.
In this case, I am appearing for the opposite party today. Kindly taken up 2 weeks after.
I am for the petition.
Stay there.
Other than that, settlement.
My lord.
Settlement then short date. No?
No, 2 weeks after. My lord.
2 weeks after.
My lord.
Obliged.
My lord.
Personal apprehension.
Yes.
Yes, already appeared one.
You are appearing.
Yes, my lord. I am.
Acha, the parties have settled, huh?
Yes, my lord.
What is the 498 now? Okay.
498 and another
And
is
in
for
the
decade.
meantime,
Okay.
mutual divorce has been allowed.
Okay.
Also, I have sought the copy.
All of them are present.
No, your lordship has directed to appear
Victim
opposite
day.
party number 2, victim, my lord, who has lost the FIR, my lord.
The petitioners have filed this petition seeking quashing of the criminal proceeding in connection with the PS case number so and so, page 7. Page 7 on the ground, full stop, also. The ground of quashment is that the parties have now settled their dispute. This settled the dispute arising out of a matrimonial discord. Affidavit who has filed, the opposite party
too.
have now filed an affidavit before this court. Affidavit
also
opposite
the-
party number 2
She is also the informant also.
being the informant in the case has filed an affidavit inter alia stating that they have separated.
Yes, my lord.
Yes, my lord.
Inter
Mutual
alia
divorce was
stating
filed and
he
that was
doesn't want
allowed.
to-
my lord.
He doesn't want to proceed with the matter against the petitioners. The petitioner number 1
Is the husband.
was the husband of opposite party number 2. Now they have separated and their mutual divorce application has already been allowed by the
Allowed.
order dated.
By the order dated, my lord.
Order dated
11/1/2024.
11/1.
24.
2024, my lord.
11/1/2024.
In CP number, my lord, 450 of 2023.
Four
450 of 2023, my lord. I have also sought the certificate.
See, as per the full sub, next one, as per the terms of the settlement, the terms of the settlement has been complied with, full stop. As per the settlement terms, the parties want to terminate this proceeding. Mr. Ragada appears for the opposite party number 1 and submits that since this dispute is arising out of a matrimonial discord and parties have settled their dispute, there is no impediment in passing the FIR. Taking into consideration the aforementioned facts and circumstances of the case, the criminal proceeding in connection to the PS number, case number so and so is set aside. It's quashed. Chalo.
Second one is also in respect to DB case, my lord, filed by the opposite party. number 8.
Item 8. In DB case, item 8, huh? DB 8.
Obliged, my lord.
7, 8.
Item 13.
13. Yes.
Wait, please, your lordship.
Yes.
My lord, in the present case, the petitioner seek the indulgence of this honorable court to quash the cognizance order dated 17/2/2022 passed by the learned JMFC Aska Ganjam Initially, the my lord, the FIR was lodged under section 498A, 323, 294, 354A,
Yes.
506, 313, 34 of IPC. But at the time of filing of charge sheet, my lord, the grievous offences like 313 was dropped, and the 354A was initiated against the mother-in-law, who is the petitioner number 2, sexual harassment by the daughter-in-law. So, my lord, the entire
It's made out, then it will be included. What to do?
against the mother-in-law, not against the brother-in-law or father-in-law.
Oh, maybe 34 is there. Under the aid of 34.
Specifically mentioned in the
Where
charge
is that?
sheet. Yes,
Show
Lord.
me.
In the charge sheet, my lord.
Where is that allegation?
Not against other
Train बांधिकिरी हाथକୁ ବାନ୍ଧି ପାଟିରେ ଲୁଗା ବନ୍ଦ କରି room ରେ ତାଲା ଦେଇ ଦେଉଥିଲେ. It's not part of the record.
No, my lord. This is a certified copy of the charge sheet.
What is the allegation?
Charge sheet, other than the Chandrakala Bhumi, she is the petitioner number 2. And against her, the 354A is initiated and not against all the other petitioners.
Okay, where is that allegation?
The allegation, it is six page FIR, my lord. This is in Odia. This is
Ah,
annexure 1, page 29.
Page?
Page 29, specifically.
Which is the relevant part?
I may be permitted to seek help because it is in Odia.
No, it's all right. Which part you tell me, I can read out.
Your
You are the mother-in-law.
All petitioners are in-laws. Father-in-law, petitioner number 1 is father-in-law.
Your case is
Against all in-laws.
354A is not made out against the mother-in-law. That's what
Mother-in-law,
you say.
my lord.
But there are all of them are accused.
Yes, my lord.
And there are allegations against the.
No, my lord, specifically, I would like to emphasize, my lord, that the informant herself stated.
Are you suggesting that you are not pressing the case insofar as the other accused are concerned? Only for the mother-in-law you are arguing?
No,
Or
for all petitions.
Then the argument that 354 is not made out is not correct, because the allegations I can read from Oria, the allegations are serious.
Yes, my lord. My lord, may kindly see. At page 34, my lords, she stated that on 16/3/2017, the petitioners assaulted her brutally. But thereafter given the contradictory statement that they took care of her for 7 days.
Contradictions and all will be tested.
Yes, my lord. My lord, but there are train tickets which I have annexed at annexion number 5, my lords. Page 51-52.
Alibi plea.
My lord.
Plea of alibi.
Yes, your lord. On 21/3, she was.
At cognizance say 482, I'll decide plea of alibi also.
Notice may be issued.
So why notice? There is nothing.
My lord, there are several contradictions there.
And you argue all these things, perhaps you may have a.
No matter may kindly be urgent. I am not fully prepared today. One chance may be given. My lord, there is a case.
Not convinced.
No, my lord, there is a case because I am not well for the last 2-3 days. My BP is fluctuating.
Okay. Your BP has come to rescue.
I have the Orissa High Court prescription also. Yesterday only.
But that will not improve the.
Yes, your lordship. No, I am not trying to improvise my version, but just for the sake of my.
But why don't you? I will make observation. Go and argue that in.
Yes, lordship. Just 2 days time.
Keep it after 2 days.
Any days, any day. Your lordship pleases. As your lordship pleases. Deeply obliged, your lordship.
On a copy of the charge sheet, maybe, sir.
Give the copy of charge.
Yes, sure.
Give the photocopy of.
Yes, sure.
And give it and place it that on record.
Highly obliged.
Yes.
Item 14.
Item 14, Your Lordship. I am for the petitioner, Your Lordship. I am seeking for an adjournment in this matter, Your Lordship. My
You mentioned in the morning.
Yes, your lordship. Yes, your lordship.
Yes.
My lord, my learned friend has taken my consent. I don't have objected because both the sides were supposed to file certain documents for your lordship. So we'll be
Yes.
Whatever you
filing it
don't
by
have
before the
objection.
next date of.
Okay.
I'll file it within
Yes, sir.
2 days, your lordship. Those documents I'll file it within 2 days. Your lordship, one more thing that if I pray for an adjournment before the lower court in the protest petition, they won't object to that.
That thing is there.
It's
That
on
thing is, that
third.
order is already that order is
Same,
already
same,
there.
same. Simply, I'm not saying anything. You move application. Yes.
Oblige,
I'm
your
not going to
lordship.
order.
Oblige, your lordship, can it be on 13th?
The date we will fix. Don't worry.
Lordship. Obliged.
My lord, may I pray for
Okay.
13th also, my lord? Because
I-
prior to that, it will be slightly difficult. Anytime after 13th, my lord.
Anytime after?
Because my senior counsel, Mr. Mahapatra, is also not available. My lord, anytime after
So
13th.
we will keep it on 29th or 30th. 29th February or 29th February. 29th February.
28th February, your lordship.
Okay,
28th.
28th. Okay.
Obliged, obliged. Lordship.
Yes.
Grateful.
Item 16.
Let's see. I have filed against the order of the cognizant order passed by the SDM Bargod dated 12/9/2023, page 15. Of the fact of the case is that the petitioner has kept his check only he has signed in his scooty and he has lost his check. So he has filed the police before the police and GD number case annexure 1. And after he has not written the date or the to whom it is given or the amount is not written. So he has filed a 1CC case. And before 1CC case and he has given the notice and reply is also given. In the 1CC case, kindly refer.
You are the accused in 138.
In 138, the name of the accused in column para 2, name and address of the accused, Govardhan Judai, son of late Sundar Judai. But petitioner's name is Harodhan Sahu. So as per the criminal.
Let us understand the fact first.
Yes. The petitioner has kept his check in his scooty. He has signed only, but name of the to whom it is given or date.
A blank check you have signed and kept it in your scooty,
Yes.
which was stolen.
Yes.
That's what you want
Yes.
to say. Next, what happened?
Then I have given the FIR.
You gave an FIR.
FIR. GD case is GD annexure 1 is the GD case. GD number 4 and the other things.
Have you mentioned who has stolen nothing?
Yes, it is.
It is simply stolen. That's what
Yes.
you said. Okay.
Yes.
Then what happened to that case?
Then here, then that Karthik, that Ketoki Gevela has filed a 1CC case before the SDM.
138.
138. And when he filed, kindly refer page 22.
Tell me.
Then Ketoki Gevela has filed. In the cost title, he has written Harodhan Sahu and son of Rajendra Sahu. As per the rule of 20 of the JRCO Criminal Volume 1, there is no title. And description and ingredients that name and address of the complaint, name and address of the accused. In name and address of the accused, it is written Govardhan Judai, son of late Sundar Judai. But notice is served to Harodhan Sahu. So as per the can refer.
Show me page 20.
Page 22.
Page 20. Where is the complaint?
Page 22.
See, notice is at page 8.
Yes.
Page 8. The Harodhan Sahu. 138 notice was issued to you.
Yes.
And you filed the reply.
Notice is given to Harodhan Sahu.
Okay, you filed the reply. Where have you said that your check was stolen or something of that sort?
Yes. I have given the reply. But he has filed the 1CC case. But in the 1CC case, as per the DRCO Rule 20, that contents and complaint of the petition, every petition of the complaint shall be contain the following particulars: the name, age, and other description of the complainant.
Where is the complaint? That's what I'm searching.
And
Where is the copy of complaint?
Yes. Page 21. And sir, that notice is given. Page 22 is the complaint petition.
Where is it? 22.
22.
22. Yes.
The name, age, and other description of the accused. So in the name, address of the accused, here it is given
Govardhan Jodai, son of late Sankar Jodai, resident of Judea Tikira, Bhuipalli, Pio Thomapalli, PS Bheden, district Bargad. But notice is given.
So how does it make difference to you? It is not, the complaint is not filed against you. Why are you bothered?
That's why I have come for
Why are you
crossing of the affair.
inviting problem for yourself?
For crossing of the affair, I have come to the no court.
Why?
Because the notice is given to me.
Notice is given, but no complaint is filed against you.
No complaint against me.
Then keep quiet. Keep quiet. Why are you? I don't understand.
Your Lordship, let me allow. Notice.
Are you Govardhan?
No. I am Horodhan Sahu.
Any case is pending against you today?
No. He has given the notice to me, Horodhan Sahu.
Let it be. The notice is now barred. He has not initiated any complaint against you. Why are you bothered?
Notice is against me, but the name, address, some of the accused given.
I don't think you have followed what I'm saying.
Yes.
You had, fact I'll tell you.
Yes.
Fact, you are not perhaps clear. Fact is, you had a check, signed check, blank signed check in your scooty, which was stolen. You gave a complaint.
Yes.
And that stolen check was presented by the opposite party. After the check was dishonored, he gave a notice to you.
Yes.
You gave a
reply.
You replied. Thereafter, nothing is filed against you. She files a complaint against some Govardhan.
Govardhan Jodai.
You are not Govardhan. Why are you asking for quashing of that?
But notice is against her.
Forget about notice, sir. If she initiate any complaint, then he come.
Yes.
No complaint is filed against you. You are seeking quashing, unnecessary inviting problem for yourself.
Lord, your Lordship, notice is given to me to appear on that such and such.
That is statutory notice under 138.
Yes.
You have already replied. If she files a complaint, then only cause of action arose.
Someone to accused person. Someone to accused person.
Which someone?
Annexure 5, page 21.
Annexure?
Annexure 5,
The court has issued summon to you.
ADGM court has issued summon against Horodhan Sahu, son of Rajan Sahu.
Then in between, she might have amended the complaint or something. This will not happen. Court, see, what is the CC case number? Just the page 16.
Yes, kindly refer cognizance order.
See, this must be a typo. She might have corrected it. Tell that.
Against me, cognizance order is also against me.
In the complaint, your name is not there. How the summons will come to you?
Lordship, page 15. Cognizance order is.
That's what I'm seeing. What is the number? ICC case number?
34/2023. Page 15. Dated 12/9/2023.
Accused persons. You Lordship rightly said that might be amended the.
Where is that complaint? You find out, you inspect it. Don't.
File kori.
Listen.
The complaint petition is also filed.
I'm no one to suggest you. Just check. Go on, inspect the record, then you press it. Otherwise, unnecessary inviting problem for yourself. Go inspect the record. I'm simply adjourning. Inspect the trial court record. See what has exactly happened.
Exactly also happened against Horodhan Sahu. Against me, notice is served by the ADGM court. But in the 1CG case, the name accused of the person is another name.
You don't follow what I'm saying. What can I tell you?
File kori certificate ko beta. Witness order hela pura amendment hoyi. Supreme Court ko mana korchi.
Go and check it, sir.
Amendment ହେଇନି.
You kindly check it.
Yes.
Let us understand the fact. From the record, it indicates there is no complaint. But somehow someone has come.
Yes.
The number of the ICC case is someone and complaint is matching. So therefore, there must be something missing in between. Just check the record. Trial court record.
It's also there.
Order sheet. So that facts will come clearly. Therefore, thereafter we will examine. You have a good case. I'm not saying that you don't have a case. I'm simply adjourning. Just check it up.
I could understand your Lordship. Simple case, the name of the accused person is other.
Do you think that I have not understood?
Other date.
Give this much credit that I could understood what you say. 20th, you just inspect and tell me the fact.
Data.
20th, 20.
Item 17.
Yeah.
May I please, Your Lordship?
Yeah.
This is questioning of the complaint case. On the ground that a reading of the complaint, it will be manifestly clear that it is a money suit which is given a color of criminal case. Your Lordship may kindly see, he advanced loan to me. I didn't repay. Then an agreement was executed in presence of the gentries. And on 5/3/21, I abused him. I threatened that I will not pay. Then he filed the complaint in 20.
Not paying is civil.
Yes.
And abusing is criminal.
Yes, but that
Both the things are mixed.
but that is super added just to make out a case. Otherwise, on a reading of the
Complaints are made out like this only. Who knows? Where is the complaint?
complaint is just page 9, my lord.
And let us see, read whether any ingredient of any offense is made out of.
My lord,
Brief facts.
shall I place the whole, my lord?
Yes, yes.
That the complainant is an innocent, law-abiding, prestigious and government retired person of the locality. That on the other hand, the accused persons are one villagers. The complainant and the accused persons had good relation between them. The accused persons are the businessmen in the locality. At the time of financial crisis, the accused persons requested the complainant to pay 2 lakhs as hand loan for development of their business. The complainant although agreed, but the complainant told that if I paid the amount, aforesaid amount, you have to return the same within 1 year. The accused agreed to this proposal and returned the same within 1 year. After that, the complainant in good faith paid an amount of 1 lakh on 11/6/18 and paid rupees 30,000 on 11/9/18 and paid 70,000 on 16/2/18 and the accused persons in total 2 lakhs. After completion of 1 year, the complainant requested to refund the money, but the accused persons took some time to repay the same. But on several requests of the complainant, the accused person did not refund the aforesaid money. So the complainant informed the matter to the village gentries to solve the matter. Accordingly, the complainant along with the accused persons are present before the village gentries, and the village gentries asked the accused persons to refund the money of the complainant, but the accused person did not listen for their ill intention. Again, the accused persons requested for time in presence of witnesses to repay the same on the same day, that is on 8/5/21. An written agreement was made wherein the accused persons agreed all the facts and promised to repay the same to the complainant, and in which they have signed in the agreement that after some months the complainant when requested again to repay his money as per agreement, but the accused persons totally refused the same. After that, the complainant compelled to issue to the accused on 11/2/22 with registered post for repayment of the loan of the complainant. The accused persons, after getting notice, did not give reply and remained silent. That on 5/3/21, the complainant
Offense.
Yes.
5/3, the complainant returned from the market, the accused person subtracted. The complainant
Yes.
and suddenly abused in filthy language.
Yes, madam.
So and so language. So and so language. Okay. After that, the complainant returned to home with the mental agony and requested the village gentry against the disclosure of the fact, and the village gentry suggested that the complainant the proper shelter in the law, and thereafter so and so. This is the problem.
This
2
is
lakhs. Why don't you pay?
no, my lord. Actually, whether it is due or not, my lord, it is to
You
be.
have agreed in the agreement. You have said that I pay.
That is a matter for the civil suit. That is my humble
Why don't you
submission.
pay? Everything will finish here. No civil, no criminal. Everything finish. Come with the we'll finish up. You have agreed before the villagers. You have agreed. Enter into an agreement, and that agreement is 21.
Yes.
And limitation is still there.
Yes.
37 suit will follow.
Yes.
So why to
But-
create problem? Finish it up here.
Your lordship may,
We will fix some installment or something. Will do. Finish it.
your lordship may notice to the
I'll
party.
issue notice and be ready to.
Yes, if it can be settled, it is better.
Issue notice to opposite party. Returnable within 1 week. 1 week Korantu. So that you be ready to 2 lakh rupees. You have taken the money installmentally. 70,000, 30,000 like that. Likewise, you also pay.
Yes, I will.
Fix the installment. come with some money.
Yes, my lord, I will advise my client likewise.
Come with at least 1 lakh or 50
Your
crore
lordship,
rupees, we will
fix-
pay and make installment and
Fix a date,
both
your
the
lord.
cases will finish.
Yes.
Wait, 1 week, sort it. 8th.
8th February. Lord, your lordship may stay for the price till then, till 8th.
You bring it within 8th, nothing will happen. That is the reason I am giving short date. Bring, I'll persuade, and both of us will persuade. 18. If he doesn't agree, then I'll stay and quash it out.
Yes.
And 37 suit he'll file or whatever.
Yes, I will.
See, he has taken the money, it's apparent. 2 lines he is adding and prepare a complaint. What is this arm twisting method?
I'm twisting.
Yes.
The petition has filed this petition for challenging the cognizance order dated 24/8/2022.
Yes.
The present petition is the employee of the NALCO, Damanjodi. FIR was lodged against that is a village dispute with regard to the Chaitra Parva and there was a feast. So there is a quarrel. Both villagers have, due to tussle, 2 persons killed, died on the spot. So FIR was, somebody has informed to the wife of the deceased that there is a quarrel. Thereafter, FIR has been lodged. On the fateful date, the present petitioner was in the duty at NALCO, at Damanjodi, my lord.
Alibi.
Yes, my lord. Thereafter, the charge sheet has been submitted against the present petition and cognizance has been taken against the present petition, although he was
302.
302 is there, my lord. There is a village dispute, let me tell you. More than 100 people were gathered, my
So your only defense is alibi.
Yes.
The alibi in the cognizance stage, can I go into alibi, please?
So that is what I know my limitation, my lord, because he's a government employee, the NALCO employee, so.
He's in custody.
No, he's not. He's absconder. Abscond.
302, what to do?
Because only 4 persons, those who are directly involved, they are in the custody. Other persons who are in,
Obviously.
they have released as well.
How many accused?
26 persons have been charged sheeted.
Where is the charge sheet?
Charge sheet I have not submitted, my lordship will call for the records. That will be better, my lord. Everything will be.
But in what way I can help you? I don't understand. The problem is that cognizance order 302, you are absconding.
I know my limitation from the very beginning. I have said that I know my limitation.
All are on bail except accused number 23, 24, 25 and 26.
Yes.
Why don't you go and ask for bail? If you have a plea of alibi and your government employee you were working on that day in Nelco. Where is the incident?
Incident on 22/4/2022.
No, the place of incident.
Place, that is.
How far it is from Nelco?
Distance, I cannot say like that. Jhariguda, that is the village of Jhariguda. Jhariguda in the.
And Nelco is in Kankana.
Damanjodi.
Damanjodi. Jhariguda is
near to Koraput.
Then he can go also there.
Jhariguda means.
Nothing can be done. Nothing can be done. You apply for bail. I don't think we can.
Lordship will direct, I will appear. I will move people. Lordship may give some protection so that I will.
What? How 302? How will I give protection? I'm just wondering what can be done. You suggest rather being.
I know my limitation. I know my limitation.
See, that's the whole difficulty. Nothing can be done. I'll just simply say that you want to withdraw the petition to avail remedy and available.
I will surrender before the court. That will take into consideration.
Surrender.
That will take your last observation because court is already only except 4 others have been released. Some of the anticipatory ballots.
I challenge this petition. I challenge challenge the cognizance order dated 24/8/2022 passed by the learned Sessions Court, Sessions Judge, Koraput.
Koraput.
You have overwritten what is that title?
Additional session judge.
Additional session judge, DJ come special judge.
Yes.
So, sir, he is an accused in the case in the FIR under section so and so, so and so. The charge sheet has been filed. He has been, the petitioner has been absconding. Therefore, this court is not inclined to interfere with the cognizance order dated 24/8 to 2022. The land counsel for the petitioner seeks to withdraw the petition to surrender before the court and avail the appropriate remedy under law.
Parry to it.
Under law.
No, parry to it.
With the said liberty, this petition is dismissed.
No, will you parry to my lord? No, parry to my lord. Well, consider.
And he further submits that he is a government employee working in the NELCO, and on the fateful day he was on duty. So there, his plea is that his only plea regarding only plea of 11 is he has the plea of 11. He has the plea of 11 to defend himself. He's not actually called. Then you so this may
Only the co-accused have been released, only parry will be taken into consideration.
No, so all these things 482 court will not. This much observation I gave so that you can persuade showing this.
Yes, same day disposal. Same day disposal.
482 you can't stress to that part. Yes.
Yeah, government employee, that is why I am pressing. Otherwise, I could have.
This much I have done.
Only same day disposal?
No. Oh, we can't do. 482, why can I do this? You surrender and take regular bail. The other people are bail 302 after all.
Yes.
Offense is so serious. Yes. I can understand if the distance is far away. The alibi could have been, Ramanjodi and Joriguda.
I don't have knowledge with the
I know that area.
Exactly.
I know, I belong to that area.
Yes,
so I know. You can go in cycle and commit the crime and come back. Yes.
28.
Yes.
Actually, 28, I required some more time to prepare.
Why? Whole day you got?
That's why today morning I got the file. I could not prepare yesterday.
Give sort date. A small issue.
Let's see.
You just see the statute evidence check and you can get the judgments also.
Madam.
Ninth.
Much better.
Prepare and come. Don't take a judgment.
39.
39. Pass over matter.
Matter arises out of a matrimonial dispute, my lord. My learned brother is appearing for the opposite party number 2. Matter has been settled between the petitioner and
there.
Lord there.
Yes. Oh, Mamta Raut. Okay. And Niranjan Barik, he's Niranjan Barik. What is the settlement terms?
Lord, they're living together.
Very good, very good. Because the petitioner's petitioner number 1. Sorry, petitioner is the husband of opposite party number 2. Opposite party number 2. Due to the matrimonial discord, the FIR was registered by the opposite party number 2.
Entering appearance for
opposite party number 2. Notice was not the on advance notice, the opposite party number 2 is appearing in person, and so and so has entered appearance and filed Vokalatnama, which is taken on record.
Attested.
The petitioner and opposite party number 2 are appearing in the court. They are being identified by their respective counsel. They have also filed the self-attested copy of the Aadhaar card to establish their identity. You have filed any affidavit?
No, my lords.
Where is the opposite party number 1 or 2? Mamta Rao? તમે સેટલ કરો ની મિચિંગ રહો છો କିଛି પ્રોબ્લેમ નહીં ચલેવની કેસ ઠીક છે this court on query from this court opposite party number 2 confirm the fact that she has started staying with her husband happily and doesn't want to proceed with the matter. Next, taking into consideration the facts and submission at the bar, the FIR number so and so, intersection so and so is caused. The upper Mr. Ragada appears, same sentence. Ragada appears and submits that Ragada appears for shape and submits that since the dispute is arising out of a matrimonial discord and the parties have settled the dispute and settled the dispute and settled the dispute and happily and revived their happy marriage. There is no impediment in quashing the FIR. Chalo.
47.
Great.
My lord, 47. My lord, I am appealing to this court. Here, my lord, Lordship kindly appreciate that the annexure 2 which has been passed by the learned SDJM, my lord, while dealing with a 457 CRPC petition, my lord, simply dismissed the petition on the ground that the IO has, my lord, disposed of the seized property. Admittedly, my lord, here is the case. What happens, my lord? One 457 petition was filed by the person who had sold the skin up to 90 numbers, which were, my lord, sold cow skin by my lord, valid transaction. Admittedly, Tata AC was seized and the, my lord, product was seized on 4th of August 2023. This is the, my lord, FIR. My lord, kindly see page starts from, my lord, page number 10, the FIR, relevant page 12, where, my lord, in contravention of section 7 of Odisha Prevention of Cow Slaughter Act 1960, my lord, the plain paper FIR was lodged by the Harrier Mishra ASI of the said police station. On that, he got information.
Who are
that
you? You are the
yes,
owner of the vehicle.
Yes. I filed the petition for release of the. Kindly see.
Who are you? Are you the owner of the vehicle?
Owner, yes.
And the accused also.
Owner of the material.
And accused.
I'm not the, yes. Another 2 accused also, blood, subsequently.
I'm asking about you. Are you the accused in the FIR?
No, I am not the accused in the FIR.
Okay.
Yes.
But you are the owner of the vehicle.
Yes. That is no doubt.
And
It is not disputed.
You filed 457.
Kindly see the order. Yes.
Yes.
This is order operative person, blood, page 16, 160.
Yes.
Blood, the second para, blood, the brief fact of the case. The petitioner is the blood A to Z Leather Jajpur Road, and he has purchased cow skin from different traders locality. The allegation prosecuted that Jagatsinghpur police seized 1 truckload of, not truckload, it's a pickup van with folded animal skin like cow skin while transporting the same illegally and without any authority, for which the vehicle with the cow skin were seized. It is alleged that the petitioner had purchased 290 number of folded animal skin like cow skin in GST number so and so, and may subsequently come to second para. The operative heard the submission, both counsel perused the entire case record along with the materials available in same. On perusal of this case record, is found that on 4th of important Millard, 4th August 2023, written report of ASI himself, Millard ASI plain paper FIR was lodged. Harrier Mishra IAC registered PS case by Jagatsinghpur PS case number so and so against the accused, namely so and so. The above named informed was seized vehicle along with the loaded animal skin like cow skin. On further perusal of the case record, is found that the case diary submitted the IO on 5th of next day. Kindly, very important, my lord, how the CRPC has been abused by the police. The 5th 8 2023, IO has dumped the seized 290 number of folded animal skin like cow skin by digging the earth inside the soil in presence of the Tarini Prasad Rai, Tahsildar cum executive magistrate Jagasimpur. Therefore, considering the CD dated 5th of August 2023, this court is of the view that seized animal skin like skin has been disposed of by the IO in presence of the executive magistrate, and such the prayer made by the petitioner disposal is rejected. My humble submission, my lord, there is a procedure has to be adopted, because once your lordship knows the 102 CRP.
What do you want if the 457 application for release of those skins and all you moved, that is no more existing in existence.
No,
Where from he'll go get it?
That
And
is
give
why
it?
the order, my lord, the SDGM has passed a wrong order, where, my lord, the procedure for seizure and report to the magistrate is to be maintained. Admittedly, the case has reported to the SDGM without, my lord, the sanction, without any order. The IO, for the reason best known to the same,
He destroyed it.
My lord, destroyed.
Destroyed it.
But destroy, whether destroy is permissible or not, that has to be kindly.
That can't be tested in 457 case application.
My lord, because I would like to, my lord, apply 102 CRPC. Kindly, my lord, see the seizure, how the in criminal case.
457, why should I get into all these things? You have other remedies. You proceed against the IO, whatever you want to do.
Exactly, my lord. I was conducting a case, my lord, Justice Satugna Pujari was dealt, and my lord saddled the entire cost on the IO, because 600 beer bottle was, my lord, manipulated. How it was seized, they are destroyed. Report was given to my state, and in that case 482, I will cite that judgment if lordship see. Honorable court has
Whether that case is arising out of 457 application.
Yes, 457, and the same court said, my lord, the
Show
court
me
said
that.
Yes,
Show me that.
I'll not reported. The court is all opined that the person the
Hey,
court
show me that judgment up.
Yes,
I
that is your also criminal miscase number 3882 of 2011, disposed upon 27th of June 2020.
Where is that?
I'll cite next. I'll file it. The copy, certified copy. I'll file it. Where, my lord, observe that a person should be not
File
remanded.
it, then if you can persuade me there, then
I'll try to persuade, my lord. The IO would not have been disposed of. He could have given Jima. There is a procedure for giving Jima. And the property is of the magistrate. It is not a case of no either.
I understand that there is no difficulty on that.
And there is a
he has no authority to destroy without seeking permission. That is
right.
very as simple as that.
Yes.
Well, what is your answer to that?
The government, that is the clause 5, the government may at any time, for the purpose of satisfying themselves as to the legality or propriety of the action taken under this section, call for or examine the record of any case, may pass such orders thereon as they may deem fit. Subject to the provision therein contained, any action taken under this section shall be final and conclusive and shall not be called in question.
No, that's not the issue. Issue is
who
has authorized him to destroy the case property.
Because in
IO doesn't have the power.
Once he has reported,
that is why he has in presence of the executive magistrate, who is
that's not permissible.
Higher officer.
Has he taken any permission? Has he taken the order? Because it is in custody and these are case property. How can you destroy the case property?
No, it's a slaughtering mallet.
Where is the proceeding for the destruction proceeding?
Yes, that is there. That might.
I issue notice, you get it.
Yes.
Issue notice to the opposite party. Write down. This is a petition filed by the petitioner challenging the order dated 18/8/2023, whereby the petitioner's application under section 457 CRPC has been rejected. The ground of rejection appears to be that the seized articles which sought to be released under section 457 CRPC has been destroyed by the IO. Mr. Mishra, appearing for the petitioner, submits that the IO has no authority under law or no authority under law to destroy the case property.
Once the seizure has been made to the magistrate.
Where admittedly the seizure has been made.
My lord, reported to magistrate SDCM on 4th
Seizure
of
has been
August.
made and reported to the
Magistrate on SDCM 4th of August.
I see. Cool, sir. Mr. Maharaj further contents that Maharaj appearing for the state contents that the destruction as it appeared from the impugn order, the destruction of the seized articles has been made in presence of the executive magistrate. In presence of the executive magistrate. Full sir. He further submits that he would seek instruction regarding the procedure followed by IO for the destruction of the seized articles. Lease the matter on 29 days.
Grateful, Lord. Obliged.
Yes.
56.
In this case, I am for opposite party wife lordship. The husband is filed its proceeding. 56. 56. CRLMC 4 to 5 of 2023.
Chakrapani.
Chakrapani, Dora. Versus
For the petitioner.
Bhanu Dora.
And for the petitioner lordship. As per the direction of this honorable court lordship,
Hmm.
the petitioner comply the order and deposit the 20,000 say for the brand up before the family court. It is the order.
What is the case?
Yes, lordship. Petitioner happened to the husband of opposite party number 2 lordship. Opposite party, your lordship, have a glass. Initially, the matter was settled between both the party in the year of 1991. Have a glass annexed to 2 lordship. That is the order. This comply not when admit the case. Court was said that you deposit 20,000. Say for the bank draft, I am comply the order of this honorable court.
Okay. Let's see what is the
I will glass the order. Order dated 31 2023. Court was specifically directed that you deposit 20,000 before the family.
Understand what is the case is about.
Case lordship. Your lordship, the petitioner challenge in the DB case lordship. Seek for the maintenance. Before going to that lordship, between both the party, year of 1991, have a glass annexed 2 lordship. Matter has been settled between the way of the permanent alimony. In a family court lordship. That lordship, when the DB case was introduced, year of 2012, he seek the monetary relief again after compromise the both the party. In that case, the learned magistrate about the 500 rupees as a maintenance. That lordship, again both the parties settled their dispute in way of the compromise of the glass annex 4. Annex 4, page 25. In that case, both are agreed to pay the 30,000 as a compromise amount.
You are supposed to pay 30,000.
Plus, in the meantime, she was getting already 25,000. Only rest of 5,000 is there. She says that is not enough. Some more may be given. Therefore, 20,000 was fixed for the compromise. Compromise petition has been filed, which was not accepted by the magistrate. For that reason, this court has directed you deposit 20,000 before that court. They have to come. This is the case.
What is your given?
Lordship, at Annex 4. My copies which are served to me is not visible, Lordship. Annex 4.
The same here, I also understand it. But you tell me what is
it is simply a compliance petition.
Passing of execution proceeding.
It is a compliance petition. Whether it is filed in court or not, it is filed before the court, but it is not drawn to notice of the presiding officer, Lordship.
In a 482 want execution proceeding.
My humbly submission, Lordship, it is not grant to the knowledge of the presiding officer, Lordship. ତାଙ୍କ କଣ compromise file କଲେ କାଇଁ କଣ order ହେଲା କି court order ହେଇଛି ଏଟା ଖାଲି compromise petition ଟା 20,000 ଟଙ୍କା ଦେବି 10,000 per ଦେବି ଏସବୁ
That was not brought before the court.
Lordship, it is a part of the
let the order be shown, Lordship.
I'm
First of
getting
all, did the order of presiding officer be shown?
certified copy, Lordship. I'm getting. It is a part of the record.
Are you agreeing with this settlement or not?
No, I am not agreeing, Lordship. I want the order of the lower court, Lordship. Whether specific order is passed by the presiding officer or not, that is a question, Lordship.
Why have you entered into settlement then?
Lordship,
Why have you entered into settlement?
to my instruction, the party not known anything, Lordship.
Who
She is a illiterate lady.
Are you disputing the signature and all?
Entered disputing, Lordship.
Huh?
Disputing.
Not once, three times you have entered.
ସେମାନେ କଣ ଗୋଟେ କଣ ଦଉଛନ୍ତି ଫାଇଲ କଣ ଦଉଛନ୍ତି କୋର୍ଟ ଅର୍ଡର କାଇଁ ପ୍ରିଜାଇଡିଂ ଅଫିସର ଅର୍ଡର କାଇଁ ମୁଁ ସେଟା କଣ କଲି
Are you disputing the signatures in the
disputing, Lordship, disputing, Lordship. ତାପରେ 500 ଟଙ୍କା କେତେବେଳେ କଣ ଦଉଛନ୍ତି କିଛି ଜଣା ପଡୁନି, Lordship.
91 ରୁ ଆଜ୍ଞା ସେପାରେଟ ହେଇକି ରହିଲେଣି 30 years.
ଆପଣ ଦ୍ୱିତୀୟ ବାହା କରିଯାଇଛନ୍ତି.
Matter was settled by taking the permanent leave. When the DB case introduced, seek for the monthly leave without taking the note of that, already matter was settled. DB case 500.
What are you doing?
I am not see Bengal মানে
Businessman.
চুড়ি বেকুছে আজ্ঞা গাম চুড়ি আজ্ঞা
You have an issue.
I know, sir. In the meantime, two daughters has been.
Two daughters.
Again, in the meantime, I am separated since 30 years, Lordship.
No, both the daughters are married.
Lord, I am also one issue from my side. ମୁଁ ତାକୁ ଆଜ୍ଞା ବାହାଘର କରିଦେଇଛି in the meantime. First wife ରୁ ଆଜ୍ଞା ମୁଁ ବାହାଘର କରିଦେଇ entire burden has been taken by me.
Why don't you settle it
30 years,
so
Lordship.
many?
କଣ ସେଠି ମୁଁ
In the between 60 years old man.
ବର୍ତ୍ତମାନ ସେ begging କରୁଛି, Lordship, to my instruction.
60
That
years
lady.
old man in the meantime.
That lady is begging, Lordship.
Unnecessary
ଆଜି ସକାଳେ ମୁଁ conducting out of
unnecessary tagging the court.
whatever this
Lordship,
case.
matter was settled. She was refused the amount. I respectfully said that as per compromise.
No, what he says that matter is settled, but she
That
disputing
is
the signature.
Lordship, my matter.
There is a thumb impression, and this
ଆପଣମାନେ ଗାଁରେ କଣ
this
ଲେଖୁଛନ୍ତି ଗୋଟେ
compromise
ଫାଇଲ
is not.
କରୁଛନ୍ତି
Court ରେ file ହେଇଛି ଆଜ୍ଞା. It's part of the record.
ହେଲେ କୋର୍ଟ ଅର୍ଡର କାଇଁ
There is no order to that effect.
ପ୍ରେସିଡେଣ୍ଟ ଅଫିସର ଅର୍ଡର କାଇଁ
That
Was
is
it
the-
Was it accepted by the court?
that was accepted with part of the record, Lordship.
Huh?
It is a part of the record. I am getting.
No, compromise you might have filed.
Ah.
But it should be accepted at the court and culminated in an order.
କୋର୍ଟ ମଧ୍ୟ ଡାକିବେ
It has
ପଚାରିବେ
not
କଣ
culminated to an order.
That was after the order, Lordship.
It has to culminate into the order, then he is correct. If there is no order, the execution will proceed. What to do? You might have compromised, whether it was
It is part of the record.
brought on record and the court.
That was accepted by the court.
କିଛି ଗୋଟେ ଫାଇଲ କରିଦେ ସାର୍ଟିଫିକେଟ କପଡା କିନା
My computer accept some
She is the illiterate lady putting thumb impression. She says, no, I have not done it. Who will go into all these things unless the court has accepted it and pass an order? Court has accepted or not, nobody knows.
I have obtained the order sheet, Lordship.
Where is that order?
I will obtain it.
Simply adjourn it. We'll see.
Lordship, the stay order be vacated.
I am deposit the money for the
20,000 rupees he paid.
A thought that be given, Lordship.
Deposit to
16. Yes.
57.
May please, your Lordship. Item 57, your Lordship, is a matrimonial dispute that has been settled by both the parties, husband and wife. Your Lordship may kindly see, three matters have come. Your Lordship may kindly permit me to place the order dated 3/5/2023 in CRLMC number 1364 by 2023. The parties have appeared before your Lordship and filed affidavit, joint affidavit, that is on record. Only the matter was adjourned that I have to produce the 13B mutual divorce certified copy of the order I was required to produce. Today that I am producing.
What are these three cases?
Three cases, your Lordship, that is one, CRLMC number.
This is 1364, 3160, and 2732.
My lord. So far 1364 by 2023 is concerned, it is for passing of 498 and other allied offences. So far 2733 by 2022 CRLMC is concerned, it is for passing of section 12 petition under the Domestic Violence Act. And so far CRLMC 3160 by 2022 is concerned, it is for passing of 125 CRPC proceeding for maintenance filed by the wife.
You have already settled now dispute.
Yes, yes.
I am appearing for the wife. Mutual divorce.
That I
Mutual
am producing. Your
You paid everything.
Everything, my lord, the order
Satisfied.
is,
The amount has been paid.
Oh, satisfied.
my lord.
What do you want?
No objection.
Are you opposing?
No, I am not opposing.
My lord only directed
Okay.
that this. No, certified copy of the work laga.
ठीक है, चलो.
I am producing today the
Right.
certificate.
May I make a small prayer? Only the grievance of the wife is that the a small hearing is with the husband. If she
No, say that. Everything has been given. How say that?
Small hearing.
it was gifted
Have
by
you
her.
taken early money?
My lord.
How much?
17 lakhs.
17 lakh. Be happy.
It was it was gifted by her mother. So
Mutual divorce हो गया, सब कुछ हो गया. देखो, all the three petition, huh? All the three petitions, one on. There are three petitions filed by all petitioners. Same.
Filed
Same.
by, yes, my lord.
Petitioner only have filed three petitions.
Chandrakanta Mishra is the petitioner, sole petitioner in CRLMC number.
Whatever, you are the petitioner in all the cases.
Along with Chandrasekhar, in-laws are there.
In-laws or maybe.
My lord.
First case.
My lord. In
The petitioners have filed three different petitions, which are
Petitioners manner, in fact case petitioners manner. Other cases have.
and
498 is the
all write down. You also write down. The petitioners have filed three different petitions. Petitions arising out of the matrimonial discord between the opposite party number 2 and her in-laws. And her in-laws. नीचे देखो CRLMC 3160 of 2022 is filed with a prayer for quashing of the proceeding in CMC number 26 of 2022 pending in the Court of Family Court, Jharsuguda under section 125 CRPC. Next. CRLMC number 2732 of 2022 is filed with a prayer to quash the proceeding in CMC number 311 of 2022 pending in the Court of SDJM Jharsuguda under section 12 of PWDV Act. CRLMC 1364 of 2023 is filed, seeking quashing of criminal proceedings in CT case number 2829 of 2022, pending in the Court of SDJM Jharsuguda under section 498A capital /323/22094/34 IPC lead with section 4 of DP Act. DP Act. Parties have now settled the dispute. Full stop. They are pursuant to the settlement terms. They filed a section. They filed section 13B of Hindu Marriage Act petition seeking dissolution of marriage by mutual consent. By the order dated 3/8/2023, the learned family court Jharsuguda in CP case number 73 of 2023 had allowed the petition and the marriage between the petitioner number 1 petitioner number 1 Chandrasekhar Mishra and opposite party number 2 Priyanka Panda has been dissolved by mutual consent. The perusal of the certified copy of the said order is placed on record. Perusal of the order indicates that the husband Chandrasekhar Mishra has paid 17 lakh rupees as a permanent alimony to the wife. And it is also agreed by the parties that the litigation pending against them will not be prosecuted hence. Next program. Therefore, the parties have filed this re-petition seeking quashing of the respective proceedings pending before different courts. Mr. Ragada appears for the state and submits that essentially this is a dispute. This is the matrimonial dispute, and the parties have decided to part away. Full stop. On the basis of the settlement, the three proceedings sought to be quashed could be quashed as there is no legal impediment. Next program. Taking into consideration the aforementioned facts and submission at the bar, the so-and-so appears for opposite party number 2 and reiterates the submission made by the petitioner. Taking into consideration the aforementioned facts and submission at the bar, the following orders are passed. All three matters. So now give your name and all. Yes. 60? Huh? 58. Yes. Yes.
Here I filed this application on 2 grounds, Mara. See, it's a complaint case wherein the court has taken cognizance in 1/6 number 5 of 2023. This same occurrence, same matter was earlier on 2 occasions before the court below, as well, it has also been advanced investigated through a step of affair. So multiplicity of application is one ground. Second ground I have taken matter that the particular complaint case is liable to be dismissed on the ground that the ratio of the judgment of the appeals court in case of Priyanka Srivastava has not been followed. Because Priyanka Srivastava has categorically in that particular judgment the appeals court is held that in each and every complaint case, the complainant is duty bound to file an affidavit indicating the fact regarding the approaching the alternative forums, that means police or any other person, vis-a-vis whether he has filed an application previous to it matter. In the particular case, as because of the fact that he has not filed the application and the court has taken not and deliberately has suppressed the fact regarding pendency of this similar dispute between the parties with the same allegation made against the petitioner. So the court will, because of the fact that it has not been complied, for that particular reason, the court below has not come to a real conclusion and proceeded further, madam. To substantiate my submission, I pray, madam, to have a glance to the allegation as has been made in the particular complaint case. It starts from page 8. Madam, may see page 9. Page 8, madam, clause number 3. Date, time, and place of occurrence. 28/9/2020. The date is irrelevant, madam. Again, I am placing 28/9/2020 in the office of Sub-Registrar Bhubaneswar, and similarly on such and such date, 2017, 2018, 2019. Thereafter, madam.
Where are you reading?
Page 8, madam. Answer 1.
Yes.
In the bottom part, madam.
Yes.
date, time and place of occurrence. The date they have mentioned it to be 28/9/2020 in the office of Sub-Register Raghunathpur, and similarly on 17/18. These are the dates. Now I claim to have turned to the next page, page 9, column number 6. Whether information lodged at local police station, if so, action taken thereunder. Yes, the complainant informed the matter before the IAC Raghunathpur police station on dated 15/3/2023, but police did not take any action, and lastly on 19/3/2023 advised the complainant to take shelter in the court of law and bring it for registration of bring an order for registration of investigation of the case.
154 followed, 155 followed. So therefore 156.
Well, I'm coming to that one. I know Malad may put the question. I'm reading that thereafter I'll answer Malad. And investigation of the case. Thereafter, complainant informed that the matter to SP Raghunathpur through registered board dated 21/3/2023, who received the same on 22/3/2023, though more than 15 days has been passed, as he has not taken any action. Thereafter, clause 7. Whether any previous complaint relating to the occurrence filed in the court, if so, the action taken. The parties that they have said no. So it is from this the court has presumed, court below has presumed that there is no previous occurrence. So accordingly, he has proceeded, and the particular Priyanka Srivastava case has not also been taken care of because of this reason, because of the fact that he has not indicated there is no previous dispute matter. Now I'm very much to have a glance to annexure number 5. It starts from page 27, madam.
Yes.
Party are same. The first para, there's no ballot, but we turn to page 30.
30.
Again.
Yes.
That for the development of the trust, as a portrait active founder members were invested their personal money and such amount. Thereafter, Romanic 3, they that Hemant Kumar Sahu, who is wicked person, if all the money that was collected from the members towards the development of the trust, apart from the same sum of trust members also contributed construction materials like such and such. Thereafter, the other trust members with good faith upon the Hemant Kumar Sahu signed over the documents and resolution prepared by him. Hemant Kumar Sahu acting as a founder, managing trustee, president, secretary, and Pradhan Acharya managed all the financial activities, excluding this complaint, and keep him in dark appointment and development the school with an intention to appropriate the public money, to misappropriate, but it has been wrongly appropriate the public money which was collected from the guardians of the students, the collection from the students, respect admission fees, such and such. Then thereafter, the date it has been mentioned, the last para, that the accused appropriate the house rent of the complainant from 2015 to till yet amounting to such and such, upon demand defer the payment, taking some false plea and others, when the student, guardians, trustees member, and the persons, those are all well-wishers of the institution, demanded amount information before the accused and his henchmen were scolded and the complainant in Hindi language and threatened to book them in false cases. That thereafter date that all of a sudden accused on 4/11/2020 entered into the school premises at about 5 a.m. and with some worker and skilled laborer with a tractor bearing number such and such. With the help of those laborers, the accused demolished the house and complainant which was rent out to the school and incasted the asbestos of the school house and uploaded the same over the alleged tractor, including the other asbestos and functions of the school. When the complainant protested, then slang language, my lord. Thereafter, that the complainant, without finding any help from the quarter, approached the local police with a written FIR on 5/11/2020. The IAC Raghunathpur registered the case as PSS number 178/2020 and directed the SI NI Vishwal for investigation. The police reached the spot and prepared a seizure list of the stolen article and on request of the complainant refused to give the copy of the seizure list to this complainant. The local police also directed the accused not to disturb the dispute resolution, that the accused with intention to grab the trust property fraudulently arranged and registered another trust deed dated 28/2019. This is important because the same things is also in the factual aspect of the other complaint case. So when this particular complaint case was pending, Investigation was pending. Thereafter, again, a case has been registered.
What happened to this case 178?
That is pending. That is pending. And that's why the Honorable Court has said in each and every case, the affidavit is a must, so that in such a case, had there been an affidavit, my lord, the concerned court would have proceeded against the particular complainant for false declaration. That is the intention of the Honorable Appeals Court, and that's why the order of the Honorable Court has been directed to be circulated to each and every registry of the Honorable Court, so that can be circulated to each and every magistrate, so that at the time of filing of the complaint case, the magistrate is directed.
Show me the judgment.
Right.
Yes, which para?
Last para, it has been directed to circulate everything. Just before the paras, it has been mentioned. Para.
The folded one you are. I was.
That is judgment, my lord. Last para, it has been directed to circulate the order of the Honorable Court. I will go to all register of the Honorable High Courts, so that it can be carried out in letter and spirit. And the very intention is even before it has been observed that why this order has to be required to be carried out by each of the report, because this in each and every complaint case where they are filing affidavit, in clause number 5 and 6, they are saying there has been either saying no, or it has been by saying goodbye to that particular things, they have said only a hint has been given that is you have filed. But the court has directed each and every article should be supported by each affidavit indicating details. When they have approached the police, what is the, if valid to be registered board, then the registered post number, all such things. The para 71, 731, sorry, page 731, para 24, is relevant part, madam. If my permits, may I place it, madam?
It may not help you, because it only says that this is the law actually. They are reiterating. See, for the purpose of 156.3, if you can't straight away come to court, you have to follow the procedure. See, you have to, a cognizance offense is made out. You have to give a complaint. Police has to register the FIR under 154. If he doesn't do, then there is a procedure of 155. You give it to the superintendent of police by registered post and all. If that doesn't fetch any result, then you file 156.3. So therefore, you have to give a declaration. And in this complaint, he has given a declaration saying that this is what I have done. What else you need?
No, madam, may turn to page 9. In such a case, madam, may turn to page 9.
Yes, I am in 9 only.
Okay. Clause 6. They have simply said that we have approached the concerned police. The police has said go and file, madam.
That's the requirement.
They have to know, madam. With all respect, it has to be specified when they have approached and in what manner, madam.
He has said lastly on date by he has given.
Madam.
And this complaint is supported by an affidavit.
Madam, that's why, my lord, my humble submission, the next one, para 7. Whether
only no written, that is neither here. This affidavit is sufficient.
So, whether, no, my lord, para clause 7, whether any previous complaint.
Except that what point you have?
No. Well, this is the vital point. My humble submission, because the fact that they have suppressed the earlier part, as I pointed out, this particular complaint case has been filed.
What? They have not suppressed. They have one word they have written no doesn't mean that the Column 3, just see.
Column 3.
Places of occurrence.
Yes.
They have given all dates.
2020.
Whatever previous this thing they have given.
Yes. The particular
So therefore the previous occurrences they have given, and column 7 and column 3, just see both. Column 7 says only no, one word.
No. What is column 7?
And in a criminal case, I will go by word to word in.
No,
this
that is
situation.
not my submission. In the particular column,
We will
7,
decide a criminal case on the basis of pleading.
No, my lord. Perhaps, my lord, I am in column number 7. It has been specifically mentioned.
No.
No.
And you read 3 now.
No. What is no, my lord? Whether any previous complaint relating to the occurrence filed in the court, if so, result thereof.
He has
That
not. He
means
said no.
Because
insofar as previous cases are concerned,
yes,
he has not given a complaint. It's all right, no problem. That you have to read vis-a-vis
No,
3.
my lord. My perhaps I am not in a position to clarify. It has been mentioned that the concerned complainant has to give a specific declaration that any previous case relating to the particular things is there or not. But as I have pointed out, he has already filed on already filed a complaint case that is also pending before the Honorable Court.
That is para 3 according to me.
Pardon?
Column 3.
No.
Yes,
Column number 3, my lord. Column number 3, my lord. Date, time, and place of occurrence means the exact occurrence for which this complaint petition has been filed, my lord.
But moreover, at the cognizant stage, I will read each and every line and
No, not, my lord.
as if a civil case, a
No, my lord.
plaint,
No.
order 7 rule.
On this, my lord knows, on the same
No cause of action is made out.
No.
So throw the suit.
No. On the sales of occurrence, true FIR or true complaint case cannot run. If anything is there,
For that you have remedy under CRPC. Analogous trial you can ask for.
No, my lord. My humble service, that's why 210. That's why 210 CRPC. If the court magistrate has found 2 parallel proceedings has been initiated by all the sales of occurrence, he can club up. But that's why clubbing.
Right.
And because the fact that he has not indicated all such things, that's why the court has taken proceeded independently and resulted in cognizance, my lord.
I will make that observation in move application.
Pardon?
For clubbing the.
No, that is that prerogative of the things is with me, my lord. My humble submission, my lord, when a particular complaint case is there, initially he has filed a complaint case. It was a FIR was registered. Thereafter it was found to be false one. Thereafter he filed a protection, which I pointed out as annex number 5. So when it is pending, there also the court has taken cognizance and proceeding against me, my lord. That is one aspect, my lord. With the same occurrence, with the same fact and circumstance, with the same date of allegation of fraudulent which has been made in the year 2020. Again, another case has been filed, and this is the subject matter of this report. At present, which I am pointing out, my lord.
That you see, everything, every pleading has to be side by side. One has to keep and look at.
No. On this, my humble submission can.
And the cognizant stage, this exercise has to be done.
My humble submission is yes, only on the ground. My lord has to see.
And looking into the complaint, prima facie case stage made out. There are many allegations.
My lord has to examine one aspect.
You went and demolished their house. You have taken money from the students.
Same allegation. The particular same allegation has been made in the previous complaint.
Where is that complaint?
That's why I pointed out, my lord. My lord may see.
Just see. Where is the complaint?
That complaint. It's all right, madam. My lord may turn to page 11. Mid part, my lord.
11.
Mid part.
That is the order.
No. In the order to cheat the complainant and other members by suppression of first board of trust by instigating other accused persons, executed registered deed.
No, you are reading this complaint only. Where is the other complaint?
Yes, man. That's why Annexure 5. Annexure 5.
Read Annexure 5.
Annexure 5, page 33, Madam Messi. Madam got it, the date, 28/9/2020.
That is one incident. There are many other incidents also. You have taken the money. You have went and demolished the house.
They are also the same thing, my lord.
Where
only my lord, kindly see. Why I am saying so? When a particular case has been filed at the initial stage, he has to come up with the particular case, whatever factual aspect. Suppose today complaint case will be filed. He has to come up with a particular case today, what has happened till today. Whatever it is going to happen.
Right.
Now suppose after 2 years or 3 years, if you will file a complaint case, I don't say there is no bar.
If it is one incident, one FIR. you can't keep on adding things on the same incident and file a separate FIR.
Yes.
That's what you want to say.
My lord.
So, see, this is, you are talking about 28/9/2020.
Right, my lord.
This is one incident.
My lord.
But the complaint which the cognizance has been taken, he has, apart from 28/9/2020, there are many other instances.
Then my lord,
Series of instances.
then my lord, for
You can't
Page-
escape out of it.
Page 35, annexure 5, page 35. The date of filing is 24th September 2021.
I've seen that.
And this complaint is page which is the subject matter of the judgment court is, my lord, 2023. It has been filed after 23. So after 2 years filed.
10/4/23.
Yes, madam. 10/4/21. So after about some 1 year or 2 months.
What is the stage of stage of trial in that case? 21 case. Stage of trial in that case.
That is pending. Cognizance has been taken, that is pending.
Huh?
Cognizance has been taken, that is pending. That's why. And the, my lord may see the date of occurrence which my rightly taken note of by the Honorable Court in clause number 3, page 8. 29/2020, 17, 18, 20, 21. So that's why, my lord. So when the complaint case has been filed in the year 2021, up to that particular period, I don't dispute the fact that yes, he can file any application or complaint case, FIR, whatever it may be, if some cause of action arose or some criminal activity has been made by the concerned person. After that only.
See, this was filed on
The application.
1 minute, 1 minute. The 1cc case 17 was filed on
1cc 17. Yes, it was filed by the
29/9/2021.
Yes, ma'am.
Okay.
Yes.
And see, there are, and now come to column 5, column 3.
Column number 3. Acha,
The
page 8,
present
madam. Annex 1. Madam, may see the dates. Save and accept 1/31/2022. All the activities dates are before that, madam. That's exactly my submission, madam.
Who is appearing? This is the only point you have.
Yes. And vis-a-vis Priyanka Srivastava, madam. Priyanka Srivastava has not been taken care of.
But accused, no, Priyanka Srivastava, you don't have a case. There you be sure. Who are the accused here? Hemant Sahu, Pramod Sahu, Prakash Mitwanda, and Lingaraj Poti. Where 17, let us see 17, who are there? Lingaraj Poti.
Lingaraj Poti. Hemant Kumar Sahu accused.
Hemanta is common, both, and Hemanta has come. I am not much persuaded, but still I'll see that if anything can be worked out, because I will simply issue notice.
No, earlier notice has been issued, entry order has been granted.
So where is the other side? What do you say?
Your Lordship, kindly have glance.
No, here, see, did you follow what he's saying? He's saying,
my lord.
insofar as the earlier complaint case 17 of 2021 concerned.
Yes, my lord.
You have filed relating to the same dispute with the trust and all. And that complaint was filed on 29/9/2021.
Yes, my lord.
Remember the date, 29/9/2021. Okay. Now come to this complaint now. This complaint in column 5, column 3. You are saying that the date and place of occurrences, all the dates you are giving, all these dates, barring one, are prior to the earlier complaint which you have filed. If the occurrence has already taken place, vis-a-vis this accused,
yes, my lord.
why have you not made that part of the earlier complaint? If you have not made part of that complaint, and you can't bring for the same incident which had already happened in 2021, you can't bring a fresh complaint in 23 and say that face the prosecution.
Yes, my lord. Just give me permission to clarify that. Your Lordship, there is so many different kinds of issues are available in this record. 1cc 16/21 is different, and 1cc 17/21 is different. Cognizance taken by the magistrate under section.
The dispute, interstate dispute between the trustee and
yes, ma'am.
And every third day something happens. You one case. You keep on filing or what?
But different in the 5/23 is so many difference. Kindly give permission to submit the
added allegations are there.
There is a firstly, in between
Did you follow? What did you follow the question of the court and the?
Yes, my lord. Yes, my lord.
Tell me.
Page 10. Kindly see the page 10.
Yes.
1cc 5/23 is different. The 27/1/16 a registered deed in between trustee above members before the sub register Raghunathpur bearing document number 4076 Semalcholji 27/1/16. Main vital issue is 5/23 1cc. The accused Hemant Kumar accused person executed a fraudulent deed, forged deed, trustee bearing number different 40762 000362 date 28/9/20. This is the more vital point. This is the different in between 1cc 16/21 or 17/21.
That is what he says. That 28/9/20
So the-
is the cause of action for the earlier complaint also.
No, my lord.
You are not.
Offense is not same. But offense is different kind.
Suppose I'll tell you. Suppose today, right now, something happened. He give you a slap. Okay, you went and filed a complaint. After 5 days, you say that at the same time, same incident, he has not given a slap, he has also abused me, another FIR. And after 9 days, or no, only he has not given a slap and abuse, he has also taken money, another FIR. Can you do that?
No.
Today's FIR, today's incident, whatever has happened, everything you have to say. That is why that Priyanka says that you have to give a declaration what has exactly happened. You can't keep on adding the FIRs after FIR because this is abuse of process of law. That is what the case is.
Actually, factual matrix is here that in between petitioner and accused Hemant Kumar in between trustee in between.
Allegations are very serious. I have seen allegations are very serious.
fraudulent deed କରିକି ସେ ଆଜ୍ଞା ଗୋଟେ ସ୍କୁଲର ପିଲା ପାଠ ପଢୁଥିଲେ ତାଙ୍କୁ ଆଜ୍ଞା ଟୋଟାଲ ହାଇଜାକ୍ କରି ନେଇ ତାଙ୍କର ଅଲଗା ଇଏ କରି ତାଙ୍କୁ କରୁଛନ୍ତି ଏମାନଙ୍କୁ ଏ ଟ୍ରଷ୍ଟିରୁ ଏମାନଙ୍କୁ ସବୁ ବାହାର କରିଦେଇଛନ୍ତି ତାଙ୍କ ସ୍କୁଲରୁ ମଧ୍ୟ ଚୋରି ଚାରି କରି ଜିନିଷ ନେଇଗଲେ ସେଟା ପୋଲିସର ଇନଭେଷ୍ଟିଗେସନ ରିପୋର୍ଟ ଅଛି ତେଣୁ ସେ ବର୍ତ୍ତମାନ କହୁଛନ୍ତି କ୍ୱାସ୍ କରିଦିଅ ଆମର ଇନଭେଷ୍ଟିଗେସନ ହଉ ରିପୋର୍ଟ ଯାହା ଆସୁ ଯାହା ହବ ଇନଭେଷ୍ଟିଗେସନ କୁ ତାହେଲେ ସେ ଡରୁଛନ୍ତି କାହିଁକି ଇନଭେଷ୍ଟିଗେସନ ହଉ କୋରେସିଭ ଆକ୍ସନ ଅର୍ଡର ନେଇକି ଟାଇମ ନେଇକି ଆଜ୍ଞା ଅଛନ୍ତି ଆମେ ଆଜ୍ଞା ସେମିତି ହଇରାଣ ପିଲା ପାଠ ପଢି ପାରୁନାହାନ୍ତି କିଛି କରିପାରୁନାହାନ୍ତି ସେଠି.
Because technically he has a case, so no coercive action. What to do? That is the problem. Once no coercive action order is there, then this will be the problem. You prepare one thing.
Investigation ta chalu habe order investigation nahi paruni. No coercive action means not to be arrested.
Otherwise, can stay the investigation. No court can stay the. No coercive action doesn't mean that staying up.
Investigation le cooperate karunanti.
Mr. Maharaj, no coercive action doesn't mean that you stop the investigation.
No, only not to arrest.
Not to arrest.
And subsequently.
Why are you not investigating?
No, investigation is going on. Only a word may be added that he will cooperate with the investigation. Because when and where required for the purpose of
investigation. Do you need a court order? If he has to do it.
Once protection is given, he will not obey.
But local police did not attend that meeting there.
If something has come up, my lord may see, what is kind enough to grant the order about a years back. Where is the complaint that any point of time I have been directed and I have not.
No, say it.
No.
Just an example. Just an example.
No.
Not that.
Have you
called the accused is doing that.
Have you called him?
No, I don't know because he is appearing.
See, no court can stay the investigation. That's very
no court can stay.
But the local police
action doesn't mean that the only he will not be arrested. He will not be arrested.
Exactly.
He will not be arrested. So, but you can't. Your police might have thought.
Exactly, sir. High Court order ଅଛି no coercive action, I am not proceeding.
Do anything.
Exactly, sir.
ସେଇଟା କିଛି
Then ତାର ସେଇଟା sir ସେ precautions ନେଇ ଚାଲିଛନ୍ତି.
Seek instruction and tell me.
ଆମକୁ କିଛି ଆମକୁ କପି କିଛି ଦେବେ ସିଏ ତାଙ୍କ
Give the copy. It is a police case now. Police is investigating. It is no more complaint case. It is 156(3). Police has stepped in.
Yes,
not we are not also added as party.
Give a copy. It is no more a complaint case.
Back tomorrow, I think.
Give a copy and you prepare a chart. 3 cases. What are the allegations?
Yes, yes.
You prepare a chart and give me.
Yes, ma'am.
And we'll keep it on 27th. 27th of this.
27.
27 February. Investigation may be proceeded.
Investigation. I am telling him. He has to give instruction. I will not pass an order. This is again. Why should?
But local police said there are no coercive action is there. High Court is there. I am not.
I am telling him, sir.
I am taking. କପି ଗୋଟେ ଆଜ୍ଞା ଆଜି ଦବା ପାଇଁ ମତେ ଗୋଟେ କପି
I also submit it today.
କପି ଦିଅ.
You give a copy so that 27th you prepare a chart. All the 3 cases.
Okay.
What are the allegations against Hemant?
Obliged.
We are examining about Hemant.
Yes,
because
ma'am.
other people have not come.
Yes, my lord.
So about Hemant, what is the allegation in the first, second, third?
Yes, my lord.
So if you prepare it and give it to the police also, the chart, it will be easier for them to investigate and file.
Positive.
Entry order continue till.
MP not to continue. Entry not to continue.
56 ଯାଇଛି ସେଟା ମତେ ଦେଇଦିଅ.
Item 60.
Yes.
Please, your lordship.
Yes.
My lord, the petitioners are there before your lordship praying for quashing of the city case number 517 by 2017 under section 498A and other allied offences. My lord, the petitioners are
Who are you?
husband and in-laws. My lord, the matter was amicably settled.
Oh, then
Your lordship may kindly see the conduct of opposite party number 2. The conduct of your lordship opposite party number 2.
You have settled. Why are you looking at?
Your lordship may kindly see. My lord has been pleased to issue notice. One RPFM was there. That is against maintenance order. It was sent to mediation. Your lordship may kindly see. She is not appearing. That is the whole problem, madam. It was sent to mediation. In mediation, the matter was amicably settled. Annexure 3 in the present petition, I have annexed even the mediation report. Now, mediation, everything has been done.
What is the understanding now?
Understand that 13B has been filed and it has been allowed. The original copy I am producing.
You have given the
testimony.
So then he is not interested.
My lord, but this is wrong, my lord. She should appear. And your lordship may kindly.
Marriage, you married, that is the biggest wrong you have committed.
Yes.
And why are you complaining today? Now you separated. You tell me service position देखो. अगर effective service and
order 29.
It's all right. If service is complete and she is not appearing, obviously why should she come?
Yes, your lordship. So let it be quashed. That is the
Service complete. Yes, Mr. Maharaj. See.
60.
60.
60.
Yes.
What happened in this case is they got separated.
Yes.
Permanent alimony taken.
Yes,
This is
yes.
mutual divorce and everything is happened.
I got it.
She will not take interest. Notice has been issued. She is not coming.
ସେ ଆସୁନି ଆଉ କଣ ଆଉ ସେଟା ଇଏ lordship may observe that and dispose.
Of course.
Yes. My lord. He has no respect to the court.
Settlement kora par see the petitioner has filed this present petition seeking quashing of the criminal proceeding in the PS case number so and so page 7. This court see the ground of quashing the parties have entered into a settlement and settlement through mediation, sir. And the mediation report dated 5/4/23 is placed on record as Annexure 3 to Annexure 3. It appears the parties have acted upon the settlement terms, and accordingly the petitioner has paid the permanent alimony of rupees 17,70,000 to the 17,70,000 to the opposite party number 2. They have also applied for, where is the divorce petition? They have also applied for the mutual, they have also applied for dissolution of marriage on mutual consent. On mutual consent. Mutual consent. Mutual consent. The Family Court Jaipur, by its order dated 15/7/2023, in CP case number 56 of 2023, allowed the prayer of the parties and dissolve their marriage under section 13B of Hindu Marriage Act and Hindu Marriage Act. In the said order also, the factum of settlement has been mentioned. This court, on when notice was issued, this court on 4/7/2023, coordinate bench of this court on 4/7/2023 issued notice to opposite party number 2 of opposite party number 2. Opposite party number 2. The matter was again taken up by the coordinate bench on 29/8/2023. The relevant is informant opposite party number 3 to IHE. So there was a direction who shall cause the same served upon the
that also
through IHE.
that also
IHE
disobeyed.
Huh?
That also by IHE also,
କିଛି ଆସିନି ଆଉ ଇନଫର୍ମେସନ ଆସିନି କିଛି
that also she disobeyed.
କିଛି ଆସିନି
No, has the IHE done it?
Yes, Your Lordship.
we have already sent we sent on 14/9/2023.
Okay, at that time.
No, the matter was again taken up by the coordinate bench of 29/8/2023.
And the court passed the following order. तो para ये पूरा 29/8/2020. Sir. Mr. Maharaj appears for the state, submits that. केवे पठिथिले?
To the IAC on 14/9/2023.
On 14/9/2023, the IAC was informed to serve the opposite party number 2. The record reveals the where is that service report?
Service of notice.
Service notice. The notice was the record reveals the notice was issued to the opposite party number 2 on give the date on such and such day, and the service is affected on her.
Yes,
affected on her. Full stop. Next one. The despite all out efforts by the registry of this court and the IO, the opposite party number chooses not to appear in this proceeding. Not to appear in this proceeding. Next, however, next Nichi. However, taking into consideration the fact that the parties have settled their dispute through mediation, and the parties have also acted upon the settlement term and obtain divorce by mutual consent. The present petition deserves merit. Mr. Maharaj submits that since the party this is the matrimonial dispute, and opposite party has already opposite party number 2 has already obtained divorce by mutual consent and received the permanent alimony. That permanent alimony. She might be she might choose not to appear in this proceeding. Next, Mr. Proceeding. Mr. Mishra, appearing for the petitioner, submits that he has also made efforts to efforts to convey uh, the opposite party number 2 to appear in the court, in the court, but to no avail, but to no avail. Next one. Taking into consideration the aforementioned facts and submission at the bar, I am of the considered view that in the prevailing, I am of the considered view that the criminal proceedings so and so. I am the considered view that the petitioner deserves the petition deserves merit, and the so and so accordingly passed.
Hon'Ble. 61. Before I take my lordship to the influent order, influent proceeding which I need to quash before your lordship. My lord, admittedly, an OEA case was filed by me. In the OEA case, the order was in my favor. The temple authorities challenged that in appeal before the appellate court. The appellate court reversed the order of the learned.
OEA under section 19.
No. Well, OEA under settlement under section 6.
That's section 6.7.
6.7 of the
Yes.
OEA. That was reversed in appeal. That has been questioned in a writ petition which is pending. There is no dispute on that.
Right.
During pendency of the writ matter, the Tahsildar Puri issued a notice under the OPLE Act. That is annexure 10.
Yes.
That notice was again questioned by me in a writ application where the operation of the notice has been stayed. That is also not a subject matter of this case. Then your lordship may kindly turn to annexure 11 at page 70. Here the dispute starts. My lord may kindly see page 70.
72.
70. This is your lordship may kindly note the letter number and the letter date. Letter
11/5/23.
Yes.
4431.
11.
Only this much is legible, the rest is not eligible. But you are relying upon that part, it's okay.
That part. But here what had happened, during the intergenum period, when the original date was pending regarding my title between either temple will get a title or I will get a title, the appellate order is under question. A fire incident occurred in the building.
Okay.
Then the municipality, after the state government could not get any relief in proceeding under the OPLE Act, when this Honorable Court interfered and stayed the order, municipality was used to give me a notice saying that my building is unsafe. So it requires to be pulled down under the provisions of 275(1) and 286(1) of the Municipal Act. This was also questioned by me. This Honorable Court said that the letter will be kept in abeyance, but I will give a show cause. My show cause will be considered and it will be decided on this. Basing on this, after this order was kept in abeyance, a 133 proceeding was initiated by the state. That is under annexure 12/A at page 74.
Yes.
My lord may kindly turn to page 75. This is the order in the 133 proceeding.
Okay, 75. Yes.
With your lordship's permission, may I place it?
Yes.
Third, the learned APP. The learned APP stated that Lakshmi Market Complex Grand Bazaar was unsafe after the fire incident dated 8/3/2023. The building is in a dangerous state and not fit for human habitation. Further, the executive officer Puri municipality has issued notice. Why 4431? Why I wanted your lordship?
That is the notice which was stated.
That's the basis of this order. 44 dated 11/5/23 under section 275 and 286 of Municipal Act. To the administrator Sri Jagannath Temple. That's why I made Jagannath Temple as a party. And Sri Chandrasekhar Manti with the petitioner to fence up and take down the said structure within a period of 1 month, failing which Executive Officer Puri Municipality may take steps for demolishing the said structure to prevent danger, and cost of doing so shall be recovered from them. And moreover, as the car festival is starting, they immediately seal the building. So, my lord, after OPLE order was stayed, municipality was given. Municipality was stayed, 133 was issued. Now what has happened, my lord?
Yeah, ultimate, what is the order in this?
Yes.
In view of the above, the Tahsildar Puri, so on, so on, so
Basing
on,
on the
directed
municipality,
seal.
sealed. Basing on this order of the municipality, it was sealed. Now what has happened? In the municipal proceedings, where I taken an order from this honorable court that I'll file my show cause, they appointed a committee and my building was assessed. What is the structure, whether it is unsafe or not? In the municipality, in the additional affidavit, my lord may kindly turn to page 3. Flag A. I'm sorry, flag A or flag B, my lord?
Flag affidavit filed by the petitioner.
Yes.
Yes.
That you are
Page,
also
page
kindly.
3.
Here, municipality passed an order on 21/20/24. My lord may kindly turn to page 5.
Page 5.
Yes.
Yes.
Of the above facts, it is found that the building is not unsafe and the notice issued by letter number 4431 dated 11/5/23 is hereby withdrawn.
That one.
That municipality letter is withdrawn. So, my lord, now the municipality letter gets withdrawn. The basis of 133 gets nullified and I am being asked to repair the building. Because of this sealing by the municipality, by 133 code, that there is an order passed by the municipality that you cannot, it's unsafe, you cannot enter into the premises, it was sealed. And car festival is there because your lordship knows in car festival.
Now they have said it is unsafe, so that order goes. That's what you want.
So now the entire proceeding has to be quashed so that I can repair as per the direction of the municipality. Municipality has given me direction to repair the building. So
Now, why after this order, why have you not applied to the that court to vary?
Yes, your lordship may kindly see the next that letter at page 5. I knew my lord will be asking me this question. But the tenant Sri Chandrasekhar Mahanti is directed to follow the recommendation of NCCBM report and NDT and PDT report and ensure all repair and restoration before any kind of intended function of the building. Further, he is also instructed to get clearance of preventive order if passed by competent court before entering into the premises. So, Malas, unless the entire proceeding is quashed, because the very basis of the proceeding is the municipality letter. Now the municipality letter is no more in existence. So 133, unless it is quashed, Malad, I cannot enter the building.
What is the remedy for 133 order? 482.
Malad, I am sitting to quash the entire proceeding. I am not challenging the order. I am challenging the entire proceeding now has to be quashed in view of this.
There is no proceeding pending. 133 absolute order.
No, Malad. It kept the proceeding pending. Your Lordship,
show me that order.
Yes.
What is the remedy available according to you against an order of 133? Against an order of 133, which is that order?
Revision.
Page 75. My lord, I am challenging the entire proceeding. My prayer in the CRLMC petition may kindly be seen. My lord.
This is the order you want to challenge, 133.
I am challenging page 74 as well as page 75. Because 74, they put me notice, pass this order expertise, put me notice, directed me to file show cause and seal the building.
What happened on 7/7/23?
My show cause is there because due to municipality clearance was not given, they kept it pending. Now the municipality has given a clearance that it is withdrawn.
I understand it. You tell me the stage of the proceeding of 133.
State
can say, I am for the temple. No, I don't have any instructions so far the 133 proceeding pendency, whether it is continuing or not.
I found from the letter, my lord.
Because it is very simple, my.
Because the letters are given to the Advocate General officials. Forwarded to Advocate General.
What is this?
This letter, what my friend is saying, that dropping of this, you will see page 5.
The additional affidavit.
Yes, it is copy submitted to Advocate General.
No, see, what is the case is.
So only thing
it was
whether
133 proceeding was initiated. CRPC proceeding was initiated.
Yes.
And they say that it is unsafe, so therefore seal it.
Sure.
So cause notice was seal it and proceeding is pending. Meanwhile, some development has taken place. Now they say that it is not unsafe, so they can proceed with that.
With certain terms conditions.
With whatever terms and conditions they follow it.
Right.
on the face of the findings now that it is unsafe, it is not unsafe. 133 proceeding goes. The only question is whether a order passed under 133 CRPC is amenable to 482 or some alternate remedy is there. You just tell me that.
It's a revision.
It's a revision, my lord.
It's not, cannot be a 482 application.
Let us see. It can't be a revision. Why I tell you? The fundamental of revision is a final order where appeal is not provided, revision lies.
Yes. Yes.
And see page 75.
Yes.
It is not a final order. It is an interlocutory order. If it is an interlocutory order, revision doesn't lie. So therefore, what lies?
And they have not disposed of the proceeding, my lord.
That's what I'm saying.
Hey, one thing, my lord. Supposing, my lord, that proceeding is pending, so far my friend is concerned, he is saying that the proceeding is continuing. That before the Sub-National Magistrate Puri. So you go and file this application along with the municipality clearance.
I asked that.
So that will be suffice the purpose of my non friend.
Going to another court to fight out.
And why this court will unnecessarily, when there is no other provision, then this court has power to interfere. When there is a provision.
When the very basis of the order, the foundation goes, why should I go again and approach the court?
No, but see, the 133 proceeding is initiated by IIC.
My lord.
Why you don't drop it in view of the development?
I will take instruction exactly point on that point, and whether this application is maintainable or not.
It is maintainable because it is interlocutory order. Revision doesn't lie. It is maintainable.
And that time, that point of time, it is maintainable when there is no other scope. When there is a scope, then why this code will interfere? Because let the master be passed then judicial order.
Instead of making circuitous route anyway, why don't you drop it? I will record it and you seek instruction, next date you come and I'll record whatever things at that transfer and show this order and tell the IIC to drop it.
The SDM will drop. Because IIC's complaint was that the SDM has
whatever they
SDM is also the authority under the state.
Judicial magistrate.
My friend can appear.
Okay, it's all right.
Judicial magistrate.
Let us see. The petitioner has filed this petition seeking passing of the passing of the entire proceeding in criminal miss case number 172 of 2023 initiated by the opposite party number 2 under section 133 CRPC pending in the where is that?
SDM Puri.
SDJM.
No, madam. Sub-divisional magistrate.
SDM Puri. Mr. Bose appearing for the petitioner has taken me to record to submit that first notice. What is that notice?
Yes, first notice is, my lord, by the municipality.
But page
72.
72. Just give me the pages. 72.
Letter number 4431 dated 11/5/20.
The record to submit that on 11/5/2023 by notice number 4431 the Puri municipality has put the petitioner to notice regarding regarding what? Regarding the unsafe nature of the building for habitation.
They exercise the power under section 275(1) and 286 of the OMF.
And 275(1) and 286(1) of Orissa
Municipal Act
1950. You have challenged that.
I have challenged that is kept in abeyance.
Good, sir. The petitioner challenged the said notice before this court.
Yes, in
by filing WPC number.
My lord, I am saying. that is WPC number 16009 of 2020.
16009
Page
of
21.
2020. By the order dated
520.
18/5/20, the coordinate bench of this court have kept the notice in advance
But directed me to file show.
and directed the petitioner to file show cause notice.
There are two WPC.
Yes.
No, next,
I have stated.
I'll come. Next.
Definitely I have stated.
Next, what happened? You say.
Next, my lord. Then they immediately started 133 proceeding. That is annexed to
When-
12 by 8.
At the when the matter stood thus, a proceeding under 133 under 133 CRPC was initiated against the petitioner. Against the petitioner. Where is that?
My lord, page 74.
Page 74. Page 74. Huh?
It's 75, ne?
75 is the order. 74 is the
74.
notice.
On
My lord, on period
3/5/2023. The learned SDM Puri, while its order dated 12/6/2023.
My lord, they sealed on 35/23, but passed an order the next month.
Directed that the subject property be sealed in view of the fact that the building is not safe. Building is not safe and the famous Rath Yatra of 2023 was scheduled. Full stop. The petitioner is challenging this order, challenging the said order dated 12/6/2023 as well. When the matter at this stage, the where is that?
That additional affidavit.
Who is it? Why? What was the occasion?
My lord, because as pursuant to the previous order of 16,009,
You gave the show cause notice?
was notice.
Acha.
They directed
In
for
pursuance to the
inspection.
show cause notice, as stated above, given by the petitioner,
Pursuant to Annexure 7.
pursuant to Annexure 7,
No, I'm sorry, Annexure 11.
pursuant to the Annexure 11, dated 11/5/2023, the who has passed this order? The executive officer, the
No, Puri municipality.
executive officer of Puri municipality has passed this order. Passed an order. The relevant part of the said order reads as under page 5, last para. In view of the above facts, it is found that additional affidavit. Well, it's on the basis of the aforementioned development, the petitioner submits that since the the municipality has now given a finding that the building is safe, safe, and the notice dated 11/5/2023, notice number 4431 dated 11/5/2023 has been withdrawn. The proceeding under section 133 CRPC has fall flat, and needs to be dropped. Next one. At this stage, Mr. Maharaja, appearing for the state, submits that he would be, in view of the development as pointed out by the learned counsel for the petitioner, he would seek instruction from the he would be seeking instruction. He would be seeking instruction.
Yes.
Instruction as to
In the above matters. In the above, with the above observation.
he would be seek instruction from the concerned authority in view of the in view of the development pointed out by Learned Counsel and in view of for the order of the Executive Magistrate, Puri Municipality, dated 20th 1/2024.
Executive officer,
Executive Officer,
Puri Municipal.
Puri Municipality. 20. ठीक है?
A free copy may be given.
A free copy may be given. कोई नहीं तो सॉरी यार यहाँ पर अकाउंट पे ड्रॉप कर दे.
ये देखिए दबा.
Keep it on 13th or 12th, 13th.
20th के रखन.
20th. Okay.
20th.
Okay. Yes.
Interim order may be extended. Interim order. is
Interim order to continue. Yes.
20th, your lordship is supposed to.
Finish. Board finish. 62. Okay.